Because unless it is listed, it cannot.
Tomorrow.
Well, they will take 48 hours time.
Tomorrow will lift it. Yes.
Lordship, a revisional application is clear. Fine. Order in view. All other orders the next year they have the time events. But the order in emergency certified copy that was obtained, there is written time for that which was affirmed. And thereafter the department we got to start with the department because the department says started by your lordship for 5 years.
Yes. Leave granted.
My lord, may we permit to mention a matter, my lord? Leave to file and my lord for moving the matter urgently, lordship, if at all today.
What is the grave urgency?
My lord, urgency is, my lord, this arises out of an arbitration proceeding where my right to adduce evidence, everything is closed, and thereafter, my lord, my application.
It will appear tomorrow.
My lord, the urgency is, your lordship, the matter is fixed today, and it's at the verge of.
It's not possible. Today it's not possible.
Yes. Kindly, well,
It will appear tomorrow.
well, item number 351 of your lordship's list, my lord. Well, only the urgency is that, my lord, the mother wants to meet his child, my lord, in respect to this puja time, my lord, so that, my lord, she can spend some time. Well, I am having the visitation, but only for this puja period. Well, if I can get 2 days so that I can, well, I can.
File an application.
Well, application, well, already filed, my lord. Well, I have already
What
filed.
is the item number?
351.
351 of the daily list.
No, 18 September 24. Last. Today.
Today's list. 351. But a calculate fixed. Please inform the other side.
Very well, my lord. Well, Omnita Das Gupta.
Calculate fixed.
Said the matter will appear tomorrow. It kindly allows the officer, my lord, to endorse your lordship.
Yes.
Grateful.
But I can leave this one tomorrow.
Item number 54 of your lordship is this. I recall the matter was heard. I have made my submission when it is completed. Thereafter, when the opposite party could not connect to virtual mode. That's why the matter is adjourned. 54.
Let me
But the thing is this, my lord, they are not paying the maintenance, taking the pendency of this application are very, very different. Is involved. Even over the lordship judgment, my lord, the order of enhancement will be
proceed serially.
If it is taken up, my lord, in this side of vacation, my lord, even if it's Monday, my lord, I
will see that it is taken up this side of the vacation.
I'm against my.
Then
let the matter be fixed on any date.
Yes. Let it appear. I will take it as serial. Yes.
I'm praying for leave to file this application without certified copy because I have not obtained a certified copy.
When the order was passed?
On 28 August, 20th August.
Yes. When have you applied?
On 4th of September.
Yes. You have the server copy?
Yes, Lordship.
My lord, I beg your lordship permission to file a revision application with it in a certified copy. It is a will permit petition, my lord. Petitioner filed an application for certified copy, all orders of the will permit case, not supplied. You made a representation to the district judge, no answer, nothing.
Right.
My lord,
you have the server copy?
nothing, my lord. No order is passed.
If no order is passed, Mr. Das, how can it take up?
My lord, we are not getting anything, my lord.
Mr. Das, unless there is any order, how can I decide that matter?
That is difficulty, my lord. I have
That
nothing.
Mr. Das, how can I decide unless there is anything?
I only paying for certified copy of all orders. I am only paying for certified copy of all orders of the proceedings.
Certified copies of the order
of will permit case.
All right.
Permitted to mention.
File it, it will appear. It's not urgent that it is to be taken.
It permit is saying leave have to be taken.
Why?
I don't know, my
lord.
If
leave to file without the certified copy.
Yes, may I permitted to mention one correction, Lordship?
And over this. Yes, sir.
One extension of interim order, my lord.
When it is expiring?
End of September, my lord.
And over this.
Notice has been served, my lord.
Yes.
The department has asked me to take, my lord, leave because the font is small, my lord. If the my lord leave to file with the small font, my lord.
The font is small. It's difficult to read also.
But it is 12. It is 12, but my lord, the department feels that it is kindly have it.
All right, keep trial court. Yes.
My lord, upgradation, my lord, tomorrow matter is fixed in trial court, my lord. 7-3, I will sleep. Tomorrow, top of the list, my lord, kindly.
That's not possible. Please, I will consider that.
Can leave to pray for can leave to file this application, my lord, to get it hard, my lord, any day, my lord, before 20th. Extra urgency is
before
20th, my lord. Next day,
20th.
20th of September.
Yes.
The interim custody of a minor 2 years daughter, my lord, has been handed over to the is directed to be handed over to the husband. My lord, and on 20th, it was directed to submit an affidavit.
All right, file it, it will appear tomorrow. Yes.
May I have your lordship stand leave to my lord file and civil division, my lord, from this circuit bench at Jalpaiguri. But the urgency is, my lord, immediately after reopening, the date is fixed before the learned trial court. So I am only
Immediately after reopening.
reopening. My
When
lord,
is the date fixed?
31st of October.
31st of October.
Yes.
From 17th, the bench will sit. 27th.
Yes, my lord.
So,
If 3-4 days.
27th, the bench will be
Instead
available.
of vacation, if you kindly we take up, my lord. My lord, only this much, my lord.
No, no, no.
Kindly, my lord.
Lashmi, can I taken up to tomorrow, my lord, any time, my lord.
Please file it.
My lord, because my lord, the 2 years baby, my lord, of minor daughter.
Sir, please file it, I've said.
My
Leave
lord
to be granted, my lord. Leave for
Leave to Didi.
great.
My lord is already upgraded. This is regarding the visitation of a child. Which is
Which
appearing,
item?
item number?
1230
1230 monthly, which has been upgraded by your lordship.
1230, it's appearing.
Yes, it is appearing. My lord, it is already in the upgraded matters. This is relating to taking the child for enter vacation. That was order passed on the earlier occasion. That was subject of challenge before your lordship in 2024. But it could not be heard out now. Same application is filed.
Mr. Rai, this was in the monthly list.
That is why, well,
So, it was filed long back.
no, that is why earlier occasion it was mentioned because this is the direction was given that every holiday.
Now, Mr. Rai, how to decide which matters are to be given precedence? You decide, I will consider in that. That's the
I can
difficult.
give you a lordship, but it is my
That
lordship.
is the difficulty because for that I have upgraded those matters, but it's difficult to reach those matters. Because the motions, regular motions are also piling up. And you have seen today the mentioning that those are to be taken up tomorrow. All are urgent. Yes, call the list.
Item number 1.
For the petition, it will be delivered. 2 p.m. Please come at 2 p.m.
Grateful.
Yes.
Item number 2.
To appear for the opposite party, Lord. It's come at my instance, Lord. It was mentioned by me yesterday.
My lord, I am for the petitioner.
As I
Why it is
indicated,
under the heading to be mentioned?
yes, because Lord, I indicated on the at the time of mentioning that there was a caveat lodged. Lord, right, caveat,
My lord, there was no, during caveat search, there was no intimation to us.
Sir, what are you saying, sir?
My lord, we have already served the copy. If he wants, I can serve him
No,
another.
no, 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 no. That's signified thing. Please see. Please see, you are saying there was no caveat noting. The first thing before filing is the caveat checking. And after that, it's returned to you. So the person who was entrusted to file
I'm
must
very
be knowing that there's a caveat.
My lord, I am very sorry. I
Will not have been intimated to you.
was. There must be a
So that this is
miscommunication.
to be vacated in interim order.
My lord, any date may be
No,
fixed, we can hear out
no,
the matter.
This is to be vacated, I will take it up. This can one for vacating.
Yes, yes.
Can one of 2025 করে দিন. This is an application for vacating the interim order. To stop, it has been stated in the said application that the interim order was on, it has been stated in the said application that the civil revision application was moved on 30th of July 2025 without serving a copy of the civil revision application upon the learned advocate for the caveator. Full stop, it appears from the endorsement made on the civil revision application that the caveat was lodged on June 30, 2025, as would be evident from the endorsement made by the concerned department on July 25, 2025. Full stop. Since the civil revision application was moved without serving a copy upon the learned advocate for the caveator, the order dated July 30, 2025 stands vacated. Full stop. List this matter under the heading motion in the monthly list of November 2025. Yes, next. Item number 3. Enter allowed. Can allow.
The opposite party. My lord, I'm led
Yes,
by
yes.
Mr. Shakur Sen, who is appearing online.
Yes,
This
sir.
is for expeditious disposal. The matter.
Because that matter that, yes, what happened?
No, they're not interested. Apparently, they have not forwarded any calculation.
My instructions are that today in the course of the day, the statement of account is being handed over. In fact, we have brought a statement which is proper. I just got instruction. It is not the correct one. So by lunchtime, I will see that it is handed over to my learned friend's advocate on record.
Direct load in the meantime, that load we will have liberty to apply before the learned judge for preponement. And not in case the learned judge does not permit preponement, then the matter at least would be taken up on 10th of November, which is the date fixed.
Yes, yes, I have no objection my lord, at all. But it is on a personal ground, my lord, the time was prayed for before the learned civil court. My time, on my ground, the time was prayed for. The diary did not permit any other time before the vacation. That is why the time was given on 10th.
No, Mr. Sen, Mr. Kos submits that if he will apply for preponement if
Yes, I have no objection. And my lord, this same party, section 11 is coming up.
9 of the arbitration conciliation.
It's otherwise ready. No objections.
Yes, I applied for vacating of the interim order because ex-parte order, my machines and everything has been.
Want the vacating to be taken up?
Yes.
Yes.
Asking for vacating and setting aside.
And my learned friend's client has already sold that machine. Receiver has not been allowed to take possession.
Selling of machine, I think my learned friend is not right because the order says that receiver will be held responsible if something happens to the machinery.
So it is before that they have sold it. Before they did not give it to the receiver.
This application under Article 227 of the
In fact, this issue, my lord, will be decided in the Section 11 court also. The matter is fixed on 22nd. Same parties.
Sir, I'm not going.
Yes, not necessary. Not necessary.
Find the Section 9 in City Civil Court. I am only on Section 9. I am not asking for any other relief.
This application under Article 227 of the Constitution of India is at the instance of, you are the borrower.
I am the borrower.
Is at the instance of the borrower. Praying for a direction upon the learned judge 13th Bay Civil Court at Calcutta to dispose of the dispose of the application, praying for recalling of the ex-parte order dated April 25, 2025 expeditiously. Mr. Kaur Learned Senior Advocate appearing for the petitioner submits that an ex-parte order was passed
on 25th of April 2025.
As far back as on April 25, 2025. The said interim order is affecting the right of the petitioner.
Kindly then record they had preferred an appeal, miscellaneous appeal from that order. That order was not interfered with. Kindly record my submission also.
We have applied there. I have shown your lordship the appeal court's order on the last.
Is operating adversely, for which the petitioner has filed an application for recalling of such ex-parte order. He further submits that unless the said recalling application is heard out expeditiously, petitioner will suffer irreparable loss and injury.
My business is closed.
As the business of the petitioner has been closed. Now, as the petitioner was compelled to close down the business for such purpose. Such submission is seriously disputed by Mr. Shane Learned, Senior Advocate for the petition for the opposite party finance company.
Yes.
Opposite party finance company. He submits that challenging the ex-parte order dated April 25, 2025, a miscellaneous appeal has been preferred by the petitioners before this court.
Yes.
Under Section 37.
Before the court at Calcutta under Section 37.
And we asked us to approach the Section 9 court.
Without interfering with the order.
Disposed of.
Disposed of.
Approach the Section 9 court.
All right.
Yes, without interfering.
Appeal preferred an appeal before this honorable court under Section 37 of the Arbitration and Conciliation Act.
This was disposed of on 17th of July.
Mr. Sen further submits that this honorable court refused to interfere with the addendum dated April 25, 2025.
Lord, please see page 84. The learned the division bench will passed an order directing appellants to respondent not to sell or create third party interest in respect of the property.
And it will continue for a period of 1 month.
My learned
And
friends,
the appellant shall not also deal with.
Call Learned Senior, in
page 84, paragraph 9.
In reply, Mr. Call Learned Senior, advocate for the petitioner, submits that the Honorable Division Bench disposed of the miscellaneous appeal by directing the petitioner to approach the court dealing with the application under section 9 of the Arbitration and
With an interim order.
Arbitration and Conciliation Act with an interim order. Full stop. However, without going into without going into the merits of the claims and counterclaims of the respective parties, Mr. Kaur further submits that since the date of hearing of the recalling application is fixed on November 10, 2025, the petitioner may be given liberty to approach the learned trial judge for preponing the date, preponing the said date of hearing. Full stop. Paragraph. In the light of the submissions made by the learned advocates for the respective parties, CO number such and such stands disposed of by requesting the learned judge, disposed of by giving liberty to the petitioner to approach the learned judge, 13 Bank Civil Court at Calcutta, to pray for with a prayer for preponement of the date of hearing of the recalling application. First of all, if such an approach is made, the learned judge is requested to consider the same in accordance with law, subject to the business of the learned trial judge. First step, in the event it is not in the event the preponement is not possible. The preponement, the prayer for preponement is not allowed. The learned judge, 13th Bench Civil Court at Calcutta, shall make an endeavor. Shall take up the hearing of the recalling application on the next date fixed, that is on November 10, 2025, and to make an endeavor to dispose of the same as expeditiously as possible, but preferably within a period of 4 weeks from the next date fixed, without granting any unnecessary adjournments to either of the parties.
Obliged, sir. Very much.
Yes, call the next matter.
And for the petitioner,
Yes,
this
Mr.
is the
Lal.
affidavit of service after serving. My lord, your lordship was pleased to, my lord, direct us to serve by hand upon the learned advocate and record. My lord, they refused, and we have served by registered post, and now they have been served. The advocate and records refused. Now, my lord, this is with regard to, my lord, custody. I am praying for, my lord, interim, my lord, custody from 29th of September and the puja vacations. Kindly first comes to page 61. This was the initial order. The order impugned, lordship, if wants to see first, my lord, order impugned is, my lord, that the child will be brought to the courtroom of the additional district judge 7 court Barashot from 10 a.m. to such and such, and there will be a special officer. Special officer has been appointed. At my instance, everything is in my instance. Now, my lord, kindly, why this has come to this? My lord, kindly comes first to page 61. This is the first order.
Yes. Is them not also appearing before the learned trial judge?
Well, they are appearing before the learned
Why
trial
they are
judge.
not appearing there?
But my lord, their directions are being passed, but she doesn't bring. Kindly comes to page 61. She doesn't comply. Simply. Kindly come. That is why I have to, well, approach the learned trial judge for modifications. So also, all these orders are all, well, admitted orders, not challenged. Page 61. Considering the facts and circumstances, I am of the opinion that petitioner, being the father, should be given permission to visit the minor child for her normal development, upbringing, a minor child needs attention of both the parents. Both the parents agree and decide that the respondent mother such and such will bring the minor child such and such from her care and custody at Axis Mall, Action Area 1, Rajarhat, on alternate Saturday on every English year month from 5 p.m. to 7 p.m. for the purpose of exclusive and unhindered interim visitation of the minor, namely such and such, with her father in presence of the mother. In terms of this, the terms and conditions as stated above is conducive and welfare for such and such. Both the parties are directed to comply with the aforesaid terms. I further held that if the visitation could not be made on the scheduled date and time physically due to any reason not within the control of the parents, in such events visitation will be made either through virtual mode, and for such virtual meeting the video links has to be exchanged by the mother to the father of the minor child on immediate next Saturday. However, I further make it clear that during such visit the petitioner will with the minor child, respondent mother will be remain present. It is also liberty to hand over gifts item and thereafter, my lord.
So this was an Axis Mall.
Yes. Now she didn't comply. I had to make an application. That application is from page 63, paragraph 4, A, B, C. These are the minor instances where she didn't bring the child. So at page 71, the learned judge directed that the child should be produced in court. This is the order passed by the learned judge. Kindly comes to page 71. This is at my instance. Upon consideration of the petition dated
So
16.
this is on the modification application.
Yes. Thereafter, again, there was a modification application. Page 71. Upon consideration of the petition dated 16/5/2023, filed by the petitioner father, namely such and such, and the suggestion of the learned advocates for both the parties, I am the opinion that the order dated such and such be modified, directing the respondent wife to produce the minor child, Yashani, on
Mr. Lahiri, this was on consent.
Yes. Now, kindly cease.
So the bringing the child before the court was on consent.
Yes, thereafter it has been modified. This is not the impugned order. Now, kindly comes. Thereafter, a memorandum of understanding was entered into for settling of the disputes, which subsequently failed. He didn't withdraw the cases and all these things. I am not going into all these things. Those are between us, so not concerning the child. Now, therefore, another application was made on 4th October 2024, page 84 kindly comes. This is the application, and thereafter kindly comes to page 89. Due to upcoming festive season, the respondent stroke mother is directed, Lordship is there, page 89.
Yes.
Respondent stroke mother is directed to allow the petitioner father access to the child for at least 2 days in Durga Puja and 4 hours on occasion of Kali Puja. As such, is court directs the respondent mother to hand over the daughter such and such on 9th October and take her back on 10th October in the evening. Petitioner is directed to hand over such and such. Thereafter, also
complied with?
Not complied with. Kindly seize my modification application again. Page 90 is my application.
Page
90. Next.
90.
Next page. This was my application. Kindly comes to page 93. And thereafter, she didn't comply. I had to file this application, and I had prayed that there should be an appointment of special officer. At page 95 is my prayer. Now kindly cease.
Special officer has been appointed.
Yes, special officer appointed.
Yes.
Page 100 is the impugned order, where special officer appointed. My contention was that the special officer may be appointed and I should be given somewhere else, because
Mr. Lahiri,
yes,
please start first. I also is of the view that this court premises may not be ideal.
No.
But considering the conduct that the mother is not producing, please start with that. it's better in these circumstances.
29th is the birthday, 26th is the birthday, Puja vacation, Kali Puja vacation.
So
She will not comply.
Mr. Lahiri,
He will not comply, and I will have to.
Mr. Lahiri, there was
Their advocates will not accept.
no. That's the miscellaneous case, Act 8 case is pending. So what is the next date fixed in the miscellaneous case?
The date.
File an application.
But this application, it will not be complied with.
I am directing
For
the
Puja vacation, at least Lordship may kindly directs.
Mr. Lahiri, no use, because several orders are passed. It's been not been complied
There is no order from this honorable court. That is my contention.
That
Is my contention, because there is no consequences in the learned trial court.
Yes.
And my lord, because of the fact that no courts will be very harsh on her until this court directs, and my lord, this direction is passed with regard to for appropriate compliance by my lord, if required by the police assistance, well, this will not be done. Lordship may kindly appoints a special officer, fixes a date. I am willing to give the remuneration. This cannot go on from 2023. Each and every occasion, once she will bring, and thereafter for some minutes I will be allowed to see my child, and thereafter go away. This also during the court premises, she remains present during the visits. She doesn't give any video link. This cannot go on like this.
This 20th, the court is open.
28th of
20 of September. So it's the third Saturday.
Yes,
It's the third Saturday.
open. Last date.
No, why last date?
Yes.
28th, 20,
Yes.
20 is also the third Saturday.
Yes.
So I'm directing the special officer who has been appointed to take steps, if not complied with, to draw the attention of the learned judge.
Kindly keeps this pending. Kindly keeps this pending. This matter pending.
Yes.
Kindly keeps this matter pending.
Uh,
And the kindly also direct.
And I also give you liberty to file an application for the Puja vacation. You file it, I will direct it to be taken up on 20th.
My lord.
Uh,
And kindly keeps this matter returnable, my lord, on next week, my lord. Kindly keeps this matter. Otherwise, my lord, this will, my lord,
Next
I will
week,
not be able to, my lord, come to your lordship in a subsequent proceedings, my lord. I have seen the rush, and it is appropriate, my lord. Kindly, my lord, keeps this matter pending, so that, my lord, there is a message that the court is monitoring.
the petitioner, Mr. Lahiri, senior advocate appearing for Next, item number 5. The Lyrie, it's difficult. In this way, it's difficult.
It is very difficult to get orders complied by, my lord.
Sort out your differences, Mr. Lyrie. Sort out your differences. Sort out your differences for the welfare of the child, for the benefit of
They
the child.
take the advantage of this, my lord. That is the difficulty. Tutoring is there, my lord. I am being further drawn away from my daughter, my lord.
Yes, yes, Mr. Chatterjee.
This is my application, my lord, for extension of interim order. But this application is.
You are approving
Yes,
Order, my lord.
tooth and nail.
Yes. Order,
Kindly
my lord,
cease-
your lordship, kindly, my lord.
কি বলছেন? কি বলছেন?
Yes.
My lord, order, my lord, if your lordship kindly, my lord, uploaded.
Right.
Yes, he used to pay for urgent plain copy.
My lord, my application, my lord, the reasons are cited is, my lord, my learned advocate has taken the fault on his shoulder, my lord, of not taking steps for extension within time.
When it expired?
My lord, it expired on, my lord, November 2024.
2024.
Expired.
Kindly sees paragraph number 3 of the application, my lord, what he has stated. Kindly looks into paragraph number 3, my lord.
Yes, my lord, he has taken that approach, his lackadaisical approach.
Advocate has taken the blame on his shoulder.
But still then, he has stated on affidavit that he was not aware that the interim order is still November 2024.
That's the new.
Every one of us, my
What
lord,
is the impugned order? Mr.
Impugned
Chatterjee?
order, my lord, is of 3 counts, my lord. First, my lord, on the
It
date.
prompted you to come just before the vacation. That is why I'm
My lord,
asking.
I am being set ex parte. My lord, they are
That was
proceeding.
long back.
No, my lord, that was
So
stayed.
maybe by this time,
No,
a decree has
court-
been passed.
no. That's my specific instruction. Court has, after there being stayed,
What is the impugned order?
impugned order, my lord, are 3. My lord, first, my lord,
3 orders.
3 orders are under challenge. My lord, first order by which I am being set ex parte, my lord, is within 12 days of service of summons, I am being set ex parte.
Cannot be done.
My lord, because I did not appear, I did not file written statement, I am set ex parte. My lord,
That's a good ground.
my lord, then, my lord, they proceeded to file amendment application, my lord, without serving a copy, that was allowed. Third, my lord, I filed an application for vacating of that ex parte, my lord, court allowed but with a cost. Noting that it could not have been done because time period, statutory time period, my lord, is, my lord,
What allowed? Ex parte vacated.
vacated, but with cost. My lord,
How much cost, Mr.
my lord, 2000. My lord, I shall deposit because my setting of ex parte was bad, my lord, and because that 2000, my lord, I did not deposit. My lord, court, in the meantime, my lord, had proceeded with, my lord, examination of PW1 and, my lord, fixed a date for argument.
Mr. Chatterjee, you are responsible for this.
My lord, I am
You
challenged.
are responsible for this. Ex parte vacated. It's not a
I
matter.
will see
It appear at what according to the choice 2000 cost. If
No.
that also you will not pay.
I was appearing.
this is a suit for eviction.
Oh, I'll show that. What is this? But if my lord, he takes me to the merit, but I'll show what fraud he is playing to the court. My lord, initially, my lord, he filed a, my lord, application before the Waqf tribunal that I have encroached. I file a suit
What
before
you
the
say?
tribunal.
2 things I can set aside that. I can because you have laid your evidence, I can permit you to cross-examine. Written statement you have filed.
Well, it's ready, but I cannot file.
Whether written statement is filed or
not
not,
filed.
that I have to take instruction.
Not on
He says
record.
ready, ready.
Ready. You know, I can
Tomorrow
file.
can you file?
No, that I have to take instruction. That I have to take a photo.
Then my lord kindly keeps it on next date. I shall come back with
Well, by
instruction
this
and my
next
lord,
week I shall file. Next week I shall file.
When? Please bring the written statement on Monday.
Mhm.
So what is the next date fixed?
That is
Next
12th
date.
November.
12th November. All right. So please bring the written statement, serving a copy of the written statement. I will allow you to file on the next date, but some cost.
But kindly appreciates me not this
If
cost
you argue,
issue.
Mr. Chatterjee, on cost, then
No, it's not about cost. Milord,
Some
it's
cost.
about, Milord, kindly see is the first order. Milord, which is under challenge. Milord,
all right,
kindly
first bring your written statement,
Yes,
then let me see.
yes.
Uh, uh, Next matter.
Number 6. For answer the petition. My application for extension of the interim order was initially granted on August 29, 2024, and thereafter extended by your lordship on
What is the application for? Extension.
extension of interim order, my lord.
It is subsisting.
It is subsisting, my lord.
Uh,
It was till
have you
end of,
stopped upon the other side?
this is my affidavit of service, my lord. It was till the end of August. I have filed my CAN application within time.
This application under Article 220.
And for the petition. The interim order expired on end of the month of August, my lord.
Have you served
Yes, yes.
the interim order after hearing the learned advocate for the
My lord, interim order is subsisting, my lord. As drawn, my lord, by your lordship.
My lord, I appear for the
By Mr. Banerjee.
petition as my lord.
who is
The
the
interim order needs to be extended.
seems to be nobody.
We have mentioned upon notice.
They are afraid of
My
you.
lord, I am appearing for the petition. my lord.
They are afraid. No. Mr. Boyd appeared for the
Last day, today nobody.
But have you notified?
Mentioned upon notice.
Some my lord, intimate problem, my lord.
My lord, this is the notice, my lord.
The learned advocate appearing for the petitioner submits that the opposite party has been duly notified. In spite of service, none appears. In spite of notice, none appears to oppose the prayer for extension of interim order. First of the interim order is extended till the end of the month of February 2026. Whichever.
Great. You asked to see.
February 2026. Let the matter retain its position in the list. What are the other matters?
This same similar millet, other orders millet. Connect.
Different orders passed or
Different,
one order
different,
passed?
different order pass millet.
No.
One is for
My lord, there were 3 orders passed during the pendency, so we had to file 3.
other 2 of 2025.
দেখে নিন যদি আলাদা থাকে আলাদা
Yes, it has been millet because I am carrying the other orders also.
Alright.
Millet.
হ্যাঁ কিন্তু আলাদা অর্ডার আছে
Yes, it has to be separate millet.
তাহলে সবকটা দিয়েই করে দিন একসঙ্গে
No, আলাদা আলাদা।
No,
No,
সবকটা দিয়ে একসঙ্গে করে দিন
no, millet there has been separate
It
orders.
cannot be uploaded. The difficult.
Separate orders. Millet.
In yes. Next.
আচ্ছা।
Number 11.
ঠিক আছে। হ্যাঁ নামটা দিয়ে দিচ্ছি।
Yes.
পুজোর আগে
Your name.
কোথায় গেল আজকে
Where is Mr. Rai?
Hello, these are the
Why it should be extended, Mr. Rai?
no, my lord, can you consider when the
It not be extended.
should be extended, my lord. I am for the
Saying
saying
no.
There is a, it appears, my lord, after filing, there one person died. In that matter, my lord,
That was adjourned.
it was adjourned.
Now you have
Petition has been filed.
within time.
It was died, no, it can be, no, 118. Prior to filing of this revisional application. So additional party, though it is substitution,
Revision is not maintainable.
but no, my lord, the addition, amendment of the cost and my lord knows better than us. Or Ambassador says,
Conservative view, revision is not maintainable, suit not maintainable.
now we are in a conservative area, my lord. Now we are Zen X.
Yes, yes.
This is an application, though it is couched in a manner is substitution, but it should be addition of party.
But Mr. Rai, can this application be allowed without hearing them?
It is served. Everything is served. Yes, yes, yes.
Who is appearing for the other side?
কি নাম জানো? Shamim.
Anyone appearing?
Yes, yes.
Yes, where is the Shamim Ahmed? Where is
Yes.
he?
He was there. He was the person who first indicated on the earlier occasion.
All right, so inform him. Can one?
Can one is for, my lord? Substitution.
Substitution of the heirs of
The opposite number
party
5. But substitution cannot be because, my lord, it is
addition.
it should be addition of party. It should be addition of party.
Opposite party number 5 is Jhapu Murmu.
Yes, Jhapu Murmu.
Which paragraph?
Substitution application here, Lord shall find at paragraph. Paragraph 5.
Yes, Mr. Rai. Paragraph 3 of that. Have you seen?
Yes.
The spelling mistake. Rejected with cost.
কি করেছে? Contempt.
Yes. Upon whom rule is to be issued, Mr. Rai?
Contempt. It's contempt.
Upon whom?
I have to take the word in, my lord. It is not the advocate record. It is my.
This can 1 of 2025.
application for extension of interim order, your lordship. Extension the respondent.
Extension of interim order. I could not hear. What did you say? No, don't correct that. Cannot correct it. Has affirmation portion. You cannot correct that. Yes.
Well, affidavit of service, your lordship. We also appeared, your lordship. For extension of interim order.
The appeal should be disposed of within a limited time.
Appeal should be
Disposed of within a limited time. Title appeal, it is in final stage of hearing. And
so stay is to be passed, directing the appeal to be.
and my lord, I am praying one for
What is the decree for?
Well, eviction decree, your lordship.
You don't want occupation charges.
Yes, my lord. For that reason, I am praying for the protection under order 41 rule 5.
Occupation charges you are paying at what rate?
Lordship, 50,000, your lordship fixed. Your lordship, I'll come to
50,000, that was a lump sum amount.
my lord, only a small shop room, your lordship. That your lordship, I'll consider.
Shop room will be small when you are for the tenant.
Lordship,
And it will be a large when it will be for the landlord.
lordship,
Same shop room will change its dimension according to which party you are representing.
7 by 12 feet of a room, lordship.
But you are exploiting it for commercial purpose. What was the rent?
303 rupees, your lordship.
Never paid. Never paid.
Yes. What do you say with regard to the occupation charges?
Lord, as per my instruction, it is near about 10 to 12,000 in that area
My
at
lord,
present.
7
It
feet
is-
12 by 12 feet, your
it
lordship. 7 by 12 feet, your lordship.
150 square feet area of the shop room.
That will not fetch. How much it will fetch? According to you?
Not 7.
I am asking you, how much according to you it will fetch? The market rate?
My lord, of that area, my lord, this is that have to take instruction. My lord, what is the market rate of that? Your lordship, but this is the backside of the.
No, maybe I am asking you what according to your estimate would be the
difficult. It's very difficult for me to express my opinion, my lord, because I am not living at that area, my lord. But the thing
you have not taken instructions from your client.
my lord, I have an instruction of that. My lord, if your lordship can keep it a short passover, then I can get instruction of that. But your lordship,
Pay 5,000 per month. Pay
my lord, it's
5,000.
very difficult, my lord. A small shop room, your lordship.
Then get a shop room of that dimension at a lower rate. You need not pay. You can vacate.
Lordship, why the appeal is important, your lordship? I know it's not on the merit level, but lordship, that it should be under Premises Tenancy Act, but it was.
He has paid this 50,000.
Yes, your lordship. It was paid.
The decree was passed when?
My lord, it was 2023, your lordship, the decree was passed.
2022, judgment dated 12 December 2022. The appeal was preferred in 2020 also. Stay order passed in December 5, 2023.
They was refused.
Stay was refused.
Appeal is ready.
Yes, ready for hearing. Final.
Is ready for hearing. So pay another 50,000. I am directing the.
Very difficult for my client, your lordship. But when a small stationery
Not
shop.
directing you to pay monthly, pay a consolidated amount because from 2022,
But your
almost
lordship,
3 years,
my lordship,
something more you have to pay. But over and above that 50,000.
my lordship, kindly consider at least a lower amount because your lordship is a small grocery shop and my lord, at the ensuing of the.
Yes, what do you say?
Lordship, a small, my friend, definitely knows the
Garment
ancient-
shop, not grocery shop. It is garment shop.
Garment shop.
But-
Yes, yes. Pay 50,000. I'm directing, what is the next date fixed?
Lordship,
What is the next date fixed?
my lord, for appeal, your lordship.
Yes, appeal.
It's in the month of November.
November. my lord.
November.
Month of November.
So I'm directing within 6 months to dispose of, pay another 50,000. Ashwin. The Can't have disposed of, can attach with
The number 1 to 4.
disposed of. In view of the order passed in the submission application, can number such and such stands disposed of. Yes, Mr. Banerjee.
I am for I am for the petitioners, my lord. But I am
Yes.
told that one of the opposite parties have expired, although no intimation has been. One of the opposite
Well,
parties.
What did you do, Mr. Banerjee?
I have just come to learn from my learned friend.
You are responsible for that.
Yes, my lord.
Yes, he says yes.
This application was filed, my lord, after the
No,
date
this
of
is
the
not- Matter is not rejection of my application under order 41 rule 27 at the appellate stage, but the appeal was not taken up, only the
But
application.
Mr. Banerjee, against the dead person,
Dead
I cannot also extend the interim order. You have to take steps.
I'll text him, let him give you the intimation, but I'll
The
text.
particulars,
well, particulars, my lord, I am very frankly stating.
you are trying.
Well, it is, I am very frankly telling you, let's say that this respondent may be deleted. Here is my other respondent. So, my lord, his mother.
Legal layers are already on record. That is what he's saying.
Or
So legal layers are, some of the legal layers are already on record.
All
Then you have to add the others.
No, no,
Please
all
give
the
me-
legal, the sons.
Wait,
Son. Wife has died. Wife has died. The 3 sons are on record. That is what he is saying.
That is.
No. Who died? Who died? Who died?
Opposite number 4, Girija Devi.
Number 4.
Girija Devi.
1, 2, and 3 are her sons.
Yes.
So,
So there is no necessity for substitution then.
no.
It is only simply deleted. Simply deleted from the final records.
No. There are two things. One, if you say some of the heirs are already on record. If you say there are other heirs, they have to be brought in. And if you say no, there are no other heirs, then only the death can be taken note of, and opposite party number 2 shall be expunged.
My lord, I am just instruction was given to me that my lord, Girija Devi is there, Girija Devi's sons is also on the record. So it is my instruction. So my lord, I am frankly telling you that's it.
There are no other legal heirs. 3 sons of
these.
There is no other legal heirs. So I'm recording that.
My lord, your lordship, my lord, then I should have my lord, filed an application.
What application?
That is when they should have filed an application to state.
So it was not within my knowledge.
It's not within the, what is the application, sir? Unnecessarily, you will file an application for taking note of that. You are making that submission. I can record that. I can expunge that.
Only expunge, your lordship.
Only expunging opposite party number 4. So I'm doing that.
Yes, I have.
Ashok, when this matter is, what is the main matter?
Main matter
My lord, I am for the petitioner.
Yes.
My lord, this civil division application is filed against the order 31st July 2025. A stay petition was filed before the concerned London Child Act, and that was dismissed.
Who are you?
I am the plaintiff in the instant case.
You are the plaintiff in the suit.
Yeah, my lord, I am plaintiff in this. My lord, in the instant case, the defendant in the
Please give me a minute. Where is your application for stay?
my lord, in the order sheet I have given, I have annexed the application for stay.
Have you filed the plaint? No.
My lord, I have not filed a claim.
Ashun. This application under Article 227 of the Constitution. Yes.
So for declaration of permanent injunction.
I am for the opposite party.
Opposite party. Yes.
Now,
Yes.
my lord, petitioner final application for temporary injunction.
Yes.
It was allowed ex parte because the defendant did not appear.
Temporary injunction allowed ex parte.
Ex parte.
Now
Now-
they preferred a miscellaneous appeal.
Appeal. Miscellaneous appeal allowed, setting aside that my lord, a complete new ground has been enunciated by the first appellate court, saying that, my lord, I will not suffer any irreparable injury. I have some alternative relief.
Yes, Mr. Boido, can I take up this matter? Any difficulty?
No, my lord. I have high scores. I have high scores.
No difficulty on my part.
Yes. Yes.
Yes.
Can you see the order input?
Yes.
The operative portion, my lord, is start from first, third, decision with reason. The perusal of the application for injunction. On perusal of the application for injunction, impugned order dated 9th October 2023, passed by the Learned Civil General Division, Third Court, Baripur, in title number 459 of 2023, and other materials and recorded, appears that the suit.
Where is your plaint?
Not
Well,
there.
plaint,
No,
not-
What is your case made out in the plaint?
and
Well,
not
kindly
annex
consider
the
the
plaint. They have not also annexed the plaint, and the first trial court's order also not annexed.
Trial court's order you have not given.
But, unfortunately, my lord, by mistake, it hasn't filed. Kindly certificate.
And my submission,
I've got a
submission, my lord, without my lord exchanging the affidavit, my lord, so many documents are necessary for the purpose of adjudication, my lord.
Well, I have.
Mr. Rai, you are saying in the civil division application affidavits have to be filed.
Well, there are so many documents, my lord. I have patta holder, patta certificate with me, but in absence of everything, the trial court.
You are submitting.
Point is that I have purchased the property. I have sell deeds. Record of right stands in my name. And we are saying they have got patta. Even if they got patta, it is a big plot.
It is
not a dispute.
Mr. Das, show me that you are in possession.
But I am
Show me,
here.
show me that you are in. What documents have you produced?
Kindly see my
Show that you are in possession.
Kindly see my lord, page 16, annexure C.
Page 16.
Annexure C. It is a record of rights. The first name, Ganesh Rai, Ganesh Gai, and last, the bottom, Biplab Gai. With the recorded Nora.
Ganesh and Biplab. You are
Yes,
Ganesh and Biplab.
Yes, my lord. And we have purchased, we have sell deeds. And so far their case is concerned, well, they are saying they've got patta. I'm not disputing it, maybe, but it is a big plot of land. Now, taking advantage of that patta, my lord, they are trying to dispossess us from the property.
And I have also record of rights in my favor, patta holder. And it is a big land, my lord, near about 18 acres. Out of 18 acres, 12 acre has already been vested. From the vested land, we got the patta. And we are enjoying last 40 years. I have also record of rights with me, and the certificate also regarding patta, and my lord, the RTI application with me.
Where is the order of the trial court?
It is page 11.
11.
Trial court is not annexed.
Annexed. Yes, yes, trial court's order has been
Annexed.
annexed.
Certificate copy is there. Original certificate.
But the appeal court did not consider the record of rights.
Lordship, and my cell deeds also.
Did not consider the record of rights.
You know, the record of rights.
Appeal could come to the finding that you are in possession and they are not in possession. What is the basis of that?
My Patta certificate, my
Yes, show me from the order that the learned appellate court has considered those and arrived at a finding. Show me the discussion.
the discussion at page, my lord, the last page,
Last page, yes.
that is, defendants are in possession of the impugned land on the
No.
basis of a patta for the last 30 years.
No, no,
Several place it has been recorded, patta.
show me the record of rights was considered. Show me the recording in the record of rights is a document of possession. You have produced the record of rights. Show me the finding of the appeal court on the basis of the record of rights where it has considered. And they have also produced the record of rights.
Here, my lord, that page, internal page.
Yes.
Internal page. Page, internal page 3, my lord. They are
Internal
also-
page 3 of the appeal court's order. Yes.
They are also,
Show me.
and first, second, paragraph. Paragraph 3,
Yes.
in middle, last, it is started, par contra, it is started, and the last line, the government granted patta in favor of the defendant as their landlord.
That is the contention. That is your contention. Show me the court's finding.
Yes, that is also recorded.
Yes, show me.
Petition with reason, my lord.
Yes.
This, the internal page 5.
Yes.
Second paragraph, this court has gone through the instant application, written objection and documents filed by the plaintiff, respondent and the defendant as well as the other materials on records. It appears that the court that the plaintiff respondent claimed to be the owners of the scheduled property. But it is prima facie appear that the plaintiff respondent of this suit.
What are the documents considered? No discussion. Mr. Rai, if I also pass a one-line order, after considering, I find they are in possession. All the materials on record. Will you accept that?
It is a details order, my lord, that.
Yes, show me the finding, which documents were considered. You have produced record of rights, they have also produced record of rights.
Yeah, I have.
Which
I have also produced the patta certificate.
Mr. Rai, it's a huge property. A portion may have vested, a portion may be in their possession.
12
So-
acres has vested and 6 acres with the possession.
How did the appeal court come to the finding that they are also claiming possession in respect of your patta property? Where is that finding?
My lord, here recorded, my lord, that in
Mr. Rai, did the appeal court consider their record of rights? The record of rights in their name. It's a document of possession. So they are also.
my favor also, patta record is there.
Yes, I appreciate that. So both the parties have produced documents. So where is the consideration of their documents? The court did not disbelieve their documents. No,
This is ex-parte order, my lord.
which order?
The trial court order.
I'm not going to the trial court's order even. I'm on the appeal court's order.
Yes.
I'm not saying. Show me from the appeal court's order. Appeal court, they have produced record of rights. You have also produced patta. So court has believed patta. What is the reason for this? It's a document of possession.
I have also document of possession, the big land.
Rai, you are refusing to understand. Show me. So there are two sets of documents. Both of you are relying upon some documents. One set of documents have been disbelieved, but silent with regard to the other side's document.
Only record of rights, nothing else. They have only showing the record of rights.
Deeds also.
A deed, my lord.
So deeds is a document of title.
Yes,
So they have to produce the record. Nothing. Show me how that.
But in that paragraph also, it is recorded. My lord,
Yes.
kindly.
Yes, yes. Show me how the appeal court has dealt with their documents. Nothing.
Yes, so the principle has been held that the plaintiff all lectures about injunction, principles of law, what is prima facie case, what is balance of convenience, but how is that been applied to the facts of this case?
Nothing like that. Non-speaking order. Practically, it's
In
non-speaking
your
order.
places, it has been recorded that I am a patta holder and that is recorded and them, they have produced some documents. Yes, my lord. Show me that finding with regard to that the court has disbelieved that. Show me one line. They are not, they failed to establish their prima facie that they are in. Oh, they have produced these documents. Rai only saying one line they have failed. Would it suffice? My possession and my patta certificate and this has been considered. And the court below. They are documents. Asun, it prima facie appears to this court. Yes.
My lord, I am for the petitioner. My lord, the wife respondent in a matrimonial suit, my lord, before your lordship, seeking expeditious disposal of a enhancement application. My lord,
Enhancement application.
enhancement of the alimony pending deleted.
When did you file that application?
2018, it was granted. I filed in 2021. From the certified copy, my lord, kindly come to order dated 7th of April 2021.
What is the next date fixed?
Next date is fixed, my lord. I am telling your lordship. My lord, it is on 20th of August 2025. It was fixed. My lord, my contention is without disposing of this application, the suit has gone into PH. Evidence is being taken up. Evidence is going on.
What is the next date fixed for hearing of this application?
My lord, it has been given 20th of August. Next date fixed. I can tell your lordship.
This application under Article 227 of the Constitution of India is
Yes.
I will please remember. My lord, key point is very short. Key point is whether in a suit which is not filed by a purchaser, stranger purchaser for partition, section 4 will be applicable or not. That's a moot question. Kindly come to page 6 of the judgment. Include judgment. Third paragraph.
Page
Page
6.
6. Third paragraph. Furthermore,
Yes.
Furthermore, section 4 of the Partition Act so and so primarily deals with situation where a stranger member, not a stranger, purchases a share in the dwelling house belonging to an individual family and then sues for partition. The court agrees to my suggestion that this application is not maintainable. Then the court subsequently observed this is kept alive for decision.
What was the application for?
Section 4. Section 4 in a suit for declaration of injunction, not for partition. Section 4 will be applicable in a suit where the stranger purchaser has applied for partition by filing a partition suit. Otherwise not.
Yes.
That's simple.
Yes.
It has not been a suit for partition.
No, not in a suit for partition, but if a stranger purchaser purchases a share in the dwelling house
Yes.
and then sues for partition.
No, we have not filed a suit for partition.
No.
No.
No. But stranger purchaser can pay for partition.
Can pay for, but he has not paid for.
Yes, and then sues for partition. Then it deals with. Please, you have a copy of the
This
partition.
point has been clearly adjudicated by the Honorable Supreme Court of India. Paragraph 10. Pat on the point, mother. Kindly see the head notes also. It must be a suit.
Paragraph
10. The requirement is that a stranger transferee of a share in a dwelling house must sue for partition.
Yes.
I am sued for partition.
Ghanteshwar versus Mohan Mohan goes. That is the parent judgment.
Yes.
That's the parent judgment.
Supreme Court held no. If it is not a suit for partition,
In the
this
said case,
section
this
4 will
court
not
has
be
taken
applicable.
up speaking through one of us. Before section 4 can apply 5 conditions. The court
I have annexed the plaint also.
should transfer the transferee of such income should be an outside of such transferee must sue for partition.
That's
So
right.
it's
That's right.
so transferee has to sue for partition. Then section 4.
Exactly, man. Kindly see.
What has been done here?
Although the suit has not been filed for partition, court observed that section 4 will be applicable.
Oh,
That's
I was
it, my lord.
I was thinking the other way around.
No.
Show me that finding.
My lord, kindly come to page 6 of the judgment.
Yes.
Kindly come to
If the
page 6 of the
application
judgment.
is allowed
Kindly
at this
just
stage,
read this page only.
where a
You
party
need not travel to other pages.
declaration is a legal action where a party seeks post declaration.
Last paragraph is important.
Even a stranger is acquired. Then section 4 can be applied, and as such the issues are required to be framed.
The court records one that is a suit for declaration.
So issue has been directed to be framed.
Yes, ma'am.
Let the application filed under section
My lord,
4.
this application was
The
filed in
application has been kept
2008.
pending, not allowed. Kept
This
pending.
observation is wrong, absolutely wrong, man. Your lordship set aside that and direct early hearing of the suit. This application was filed in 2008 and disposed of in 2025. One application.
Mr. Chakraborty, if I have to set aside this, I have to give them notice.
Yes.
But or I can do one thing. So I can give you liberty since that application is pending, not yet disposed of. I can give you liberty to raise this point and to rely upon this judgment at the appropriate stage when this application will be taken up. Otherwise, it will be delayed.
At the same time, I will give a direction. The suit will be disposed of immediately.
That I will do. That will be done.
Yes.
Otherwise, it will be delayed. It will be
Immediately,
delayed
that-
because the
that-
application is pending. That I have seen. That it has not been disposed of.
But observation is not correct. make some observation.
Against observation, Mr. Chakraborty, civil division application does not lie. It's the
Anyway.
operating part. It's the operating part. I'm recording your submission. Where is the plaint?
Page
Page 15.
Page 15, well, 1-5.
1-5. Prayers
Prayer, page 33, well,
33. No, 28.
28.
And where is the section 4?
Section 4 application.
Have you
Page
annexed?
40, my lord, page 40.
40.
40.
Why have you annexed so many documents? This is a short.
Good client, my lord.
This Why adjournment? Please start.
My lord, I unfortunately am not briefed in the matter. I am unable to assist your lordship any
My
further.
lord, for item number 18, my lord, I am appearing for the petitioner.
Yes. You are for the
I'm for the respondent number 1.
opposite.
My lord, I would have, my lord, we had affected service, but I was also, my lord, praying if we could come back next week. Only a very small point of law is involved, which is why we affected service. Section 8 of the Section 8 of the Land Reforms Act, my lord, I am the preemptee. He, my learned friend, appearing for is the preemptor. In fact, the original, my vendors have also been added as a party. So I don't know who my learned friend is appearing for. They file an application under Section 8, which was pending. I file an Order 7, Rule 11. On the limited count that Section 8 will not be applicable when, my lord, the entire property has been sold off and not a portion thereof. That was the limited scope in my 711. Now, there are some judgments, my lord, I'll be very candid. Some judgments are going against me. And there are some judgments that I am, my lord, using in my favor, which are going squarely in my favor. My lord will have to decide this issue, my lord.
It's pending before the larger bench.
No, my lord. At this juncture, my lord, as I had taken instruction, as per my instruction, my lord, presently there is nothing pending before the larger bench. Subject to correction, my lord.
Sir, is pending.
My lord, may I, my lord?
Sir, Mr. Rai, entire share of the plot of land is pending. Yes, give me the reference. The issue that arises for
My
consideration.
lord, may I, my lord, come back? I'm led by a senior, my lord. But I'll just come back for 5 minutes.
Larger bench, I am adjourning this. This matter issue is pending before the larger bench.
Oh, very well. But could I come back any day just for to take another adjournment? To take another adjournment, could I come back, my lord?
Mr. Rai, please give me that. The learned advocate appearing for the petitioner submits that by the impugned order, the application under Order 7, Rule 11 of the Code of Civil Procedure, praying for rejection of the miscellaneous case file under Section 8 and 9 of the West Bengal Land Reforms Act 1955 stood rejected. So he further submits that the ground for rejection of the plaint is that the vendor of the petitioner herein has transferred his entire share in the plot of land to the petitioner. First off, such an issue is pending. Now, a more or less identical issue is pending consideration before the Honorable Larger Bench. First up, in view thereof, the civil division application is admitted. First up, list this matter. Now, let the matter go out of the list for the present with liberty to the parties to pray for its inclusion after the issue is decided by the Honorable Larger Bench.
Only one small I'm sorry, my lord.
Yes, then the suit has to be stayed.
Yes, my lord, because it's fixed for final hearing.
There shall be an order of stay of all further proceedings in Preemption case number 6 of 2022, pending before the learned civil judge within bracket Junior Division 2nd Court at Durgapur till the disposal of the civil division application. Yes, Mr. Rai, have you got it? All right. Mr. Pending before the larger bench, বলে ওখানে reference টা করে দেবেন. Mr. Rai, please do something. Suits, other things, all proceedings are stalled.
References are already there. Bus suit still pending. Intershare pending. Then, my lord, whether we
Short consideration.
that, my lord, after Abdul Wazir Mollik, it's these two is the main thing.
It's also there is nothing. Intershare, there is nothing, but
In view of the
Chanarani, thereafter the division bench.
all the problem caused by Chanarani.
Yes, after Chanarani, the division bench.
Division bench.
Nothing
The
remains.
answer is not been given by the division bench. Chanarani. Chanarani is something else that is continuous study itself. Entire plot of land transferred, inspired and directed.
Language is clear.
Adjoining landowner is entitled to get a notice, which is not there in the statute. I am supplying the number two.
Yes, call the next matter.
I'm extremely grateful to my lord.
Please give your appearance, sir.
My lord, my lord, may I give my appearance in the chat box, my lord?
Yes, yes, yes,
I'm
call the
grateful.
Item number 19.
Well, this is an expeditious disposal of
19,
the appeal.
I have been asked to appear on behalf of the respondent appellant.
Giving
Malad, in course of this day, Malad, I shall file my.
expeditious hearing, what?
No, not expeditious hearing.
Yes, yes, he's praying for expeditious
Disposal
hearing.
of the appeal, lordship. Appeal pending since 2019.
Yes.
They got interim order of injunction as well as that.
I am directing to be disposed of.
Next date on 18th of December 2025.
18th of December 2025.
My lord, injunction application is pending. They have taken interim.
Oh, injunction application. I am directing the injunction.
Injunction as well as appeal, lordship.
Yes. This application under Article 227 of the Constitution of India is at the instance
I am for the petitioner, my lord. In this matter, I am praying for expeditious disposal of the title suit number 218 of 2020.
what is the stage of the suit?
My lord, I have filed an application for substitution of a deceased defendant number 1 on 19th July 2025.
That is pending.
That is pending, my lord. And the suit is also pending since 2023 and it is marked as ex-parte, my lord.
This application under Article 227 of the Constitution of
I filed this case challenging the order dated 26 August 2025, my lord.
Yes.
First, in a proceeding under section 151, my lord, in a miss case, my lord, the opposite party is a finance company, my lord, and I am the defendant, my lord, here, and the petitioner hearing the defendant purchased one truck with a financial assistance from the opposite party, my lord. And notice has been served, my lord. Kindly come to page 18, my lord.
Yes.
Notice has been served for the vehicle number WB41D6226. And my lord,
Page?
my lord,
Page.
page 18, my lord.
18.
18, my lord.
Yes.
18, my lord.
Vehicle number?
Vehicle number 41D6226. Is that
Which order you are challenging?
I am challenging the order is the impugned order under section 151, my lord.
Yes,
And
151, what has been done?
my lord.
What has been done by the?
My lord, what happened? Kindly come to page 20, my lord. My one bus has been not hypothecated but by that company, my lord. We had not purchased from the finance. I have purchased that bus from the financial assistance of the different financial company, my lord. That has been receiver has been appointed to that particular vehicle, my lord.
But this is a consent order.
No.
Yes, yes. You are challenging the order dated 26th of August 2025.
Yes.
Please turn over to the next page. On consent of both parties,
No, my lord,
respondents are directed to hand over the vehicle.
no consent was given, my lord.
Sir, I
No
cannot say.
written consent was
Then
given.
you have to apply there. I give you liberty to say that no consent was. This is a consent order. How can I interfere?
Report is taken up to take the respondent appears by the.
You have given consent, sir.
On consent.
Yes.
Yes, next page. But no consent was given, my lord.
That I cannot
That
decide.
vehicle was not hypothecated to that company.
Make an application that you did not give any consent. I give you liberty to.
My lord.
Here it cannot be done.
Liberty may be given to my lord.
Yes, I will give you liberty to approach there to
My
say that there is no consent.
And mentality the challenge, my lord. Challenge the mentality of this case, my lord.
Everything you do there, not here.
My lord.
This application under Article 220. Yes.
I am filed this application for expeditious hearing of a partition suit filed in the year 2014.
Yes, what is the stage of the suit?
A temporary injunction application has not been heard.
This application under Article 227 of the
My lord, item 23, I'm appearing for the petitioner.
yes, yes.
My lord, I'm praying for this is an expeditious disposal application. My lord, title suit pending since 2014.
Injunction application disposed of.
My lord, disposed of. Commissioner report has been completed long back, but my lord, respondent are with an intention to delay. They have filed a resumption petition, whereas there is nothing to work on by the commissioner and else. Commissioner work has been completed, but the suit has not been proceeded due to this delaying tactics of the respondents, my lord. Suit has been pending since 11 years.
No, no, injunction application is pending, madam. What are you saying? The injunction application is pending.
That is not the injunction application, my lord. That is the resumption petition they have filed.
No, no, please kindly come to the order dated 13th of August 2025. The interim order of injunction is extended till that date. It presupposes that the injunction application is pending.
Injunction has been granted, my lord, earlier. That has been extended.
Madam, ad interim granted, temporary not granted, application is pending. This application under Article 227 of the Constitution of India is at the instance of the plaintiff praying for a direction upon the learned additional district judge, praying
Additional civil judge, my lord.
for a direction upon the learned civil judge junior division additional court at Alipur, District 24 Pogona South to dispose of the title suit number 21580 of 2014 expeditiously. Full stop from the in view of the order sought and proposed to be passed according from the order sheets appended to this application, this court finds that the application for temporary injunction is still pending. Full stop. In view of the order sought and proposed to be passed next, in the light of the submissions made by the learned advocate for the petition, CO number such and such stands disposed of by requesting the learned civil judge, junior division, it's first additional court or only additional court?
First additional court, my lord.
But you have not mentioned that in the cost title. You have not mentioned first additional court. First additional court. একদম না উপরে লিফটটা দিয়ে দেবেন to correct the cost title. ঠিক আছে? ফার্স্ট অ্যাডিশনাল কোর্ট প্রথমটা তো কিন্তু ফার্স্ট অ্যাডিশনাল কোর্ট লিখে দেবেন আর লিফটা দিয়ে দেবেন। না না পুরো সেন্টেন্সটা করে বলে দেবো। হ্যাঁ, লিভ ইজ গ্রান্টেড, লিভ গ্রান্টেড। এটা কি হলো? The Learned Civil Judge Junior Division First Additional Court at Alipur to dispose of the application for temporary injunction filed in title suit number 21580 of 2014 expeditiously. First of after disposal of the application for temporary injunction and any and all other and any other interlocutory applications that may be pending, the learned trial judge shall make an endeavor to dispose of the title suit expeditiously, keeping in mind that the suit is pending from the year 2014. Yes, next.
Grateful, my lord.
24, my lord, in this matter, waiting for the petition.
Yes.
There is a caveat, my lord, the copy has been served.
For the caveat.
Shinjini Chakraborty.
Shinjini Chakraborty. Yes.
Challenging the order passed an election petition under the Panchayat Act.
Passing an order, challenging an order passed by the?
Passed in an election petition under the Panchayat Act.
It is to be heard finally.
One thing, my lord, the question cropped up for consideration before this tribunal, before the election tribunal, is that a contract which has particular specific period, for a particular period, whether the existence of the contract can be continued to be there after the
contract.
Yes,
because the election tribunal.
Yes, because the question cropped up for consideration is the allegation was made by the opposite party herein that I am the existing contractor of the said Gram Panchayat.
Yes.
Panchayat Samiti. In view of the provision as laid down.
What did you do? You participated in the election.
I participated as the election return candidate. My election has been set aside.
Your election has been set aside on the ground
that I am an existing contractor when I filed the nomination paper.
So existing contractor, where is the finding? It has been made that he is not eligible to participate.
Yes. That
or contest. Where is that?
That, my lord, election first thing, my lord, a royal lordship is
show me the finding first, then I will go.
Findings. Yes. Page 12, your lordship find. The findings are only on the findings I am placing your lordship. Concerning the documentary evidences, page 12. Record in view of the citation referred to as advocate Christian Cleveland's court. Respondent number 6, who is the petitioner of your lordship, who is the proprietor of Nosip Construction, got work order number such and such, whose NIT number 6, memo number such and such, and that said work order not yet been completed and so has not yet been terminated. From exhibit 15.
There is a dispute with regard to this fact.
Now the termination.
Dispute with regard to this fact.
Kindly turn to the.
No, then what finding? Considering the documents, this is the observation.
It is the observation.
No, what is the finding that you cannot contest? Where is that?
Yes, after that, my lord.
Show me that.
Therefore, this court is without a reason hold the conclusion. Petitioner is entitled to get relief as to the prayer made in the election petition such and such. He is hereby declared OP number 6 is not qualified to be nomination, being disqualified in the meaning of section 7 subsection 3 II to the Act of 23 2003 and for making untruths represented in.
Where are you getting that?
Last part, one paragraph. Ordered.
Yes. Prior to that.
After that, it is hereby declared.
It is hereby declared that opposite party is not qualified to file the nomination, being disqualified within the meaning of 7C2 of the Act and what is for? And it should be for making untrue representation in his
nomination. Now, my lord, apropos to this.
So there are two things. One factual aspect that you have made untrue.
Yes.
You may have stated that yes, I have not.
I have not connected with any work order at the time of filing the nomination paper. Second, that
is not the correct true.
Yes, turn to page 37. Apropos to this, that is why, my lord, I am submitting
37
up because the writ petition was filed by the private respondent, not private respondent, the objector before this honorable court. Page 37 is the relevant portion, my lord. I am Second paragraph. Learned advocate representing the private respondent.
Second, yes.
Communication, there is no existing contract between the Gram Panchayat and the private respondent. They said the communication did such and such. So it also mentioned that she is not aware of any communication addressed to the petitioner. The private response special content, there is no existing contract between the Gram Panchayat and the private respondent subsisting
So
on
who is the private respondent in the writ petition? You, yes.
The learned advocate representing the state respondent submits that the petitioner filed his nomination for contesting the election, but thereafter withdraw the same. It is the
That is the petitioner is the opposite party.
hearing. From the work order, now what is the finding? Work order, it appears that the time schedule for completion of the work was 30 days from the date of its issue. Going by this time schedule mentioned in this work order date such and such, the contract ought to have been over by February 20, 2021. So whether the contract
thereafter contains that till late 2023, Mr. Rai, it's not complete. What order you have annexed?
এইভাবে এসছে next page 103.
But
it doesn't mean anything.
No, I think you have taken in A4, but it was in legal. It has not come. What have you done?
No, after that, it is challenging the candidacy. This is a finding of the court that it is for 1 year, is up to 2021 February. Now,
so here it has been left that is challenging the candidature. It will be well open to
election petition.
So that has been done.
So this is the findings and this is the nature of the work order.
No conclusive finding.
That one, conclusive finding is not on that. So it is a contract.
With the law.
Yes. Now, how these findings are subsequently considered, how the existence of the work order is considered, that I'll come. Before that, one, I draw lots of attention over the provision of section 7. If you Joshua ke deben.
Panchayat Act নেই আমাদের কাছে Panchayat.
Malad will find the same thing has been quoted in the order itself.
In case of a Panchayat Samiti directly or indirectly by himself or his partner, any share or interest in any contract with, by or on behalf of the Panchayat within the block concerned or Jila Parishad as the case may be, provided that no person shall be deemed to be disqualified. এটা দিয়ে দিন ওনাকে। No, Elections Act আছে তো এখানে? Elections Act নেই।
Election Act is not in the Panchayat Act. ওটার মধ্যে নেই, আলাদা করে আছে।
ওটা একটা সেপারেট বই আছে। Relevant point of time, the contract was terminated.
There is no that came up for consideration of the Honorable Court. When there is specific terms for awarding a contract, it's a factor that contract died on the date of influx.
But Mr. Rai, if the maybe in the work order a specific time limit has been fixed, but you have not completed and you are still continuing or you are allowed to continue.
That is the thing, my lord. After that, there must be something on record or board to say that I am allowed to continue that work order. The finding is that I am not withdrawing the earnest money deposited. That is presupposes that I am continuing the contract. Today, my lord, I have to consider whether this determinate contract can be continued to be enforced under the specific act also or not. देखिए जोश ये तक देखिए
So, admittedly, earnest money was not withdrawn by you. So, but your contention would be whether I withdraw that or not.
That is immaterial.
That's immaterial.
Whether there is subsisting contract on the date. Because this came up for consideration before this Honorable Court also. I am relying upon judgment reported in 2018 SEC Online Calcutta 9056, where this Honorable Court in Gorkha Territorial Administration just kindly turn to paragraph 9 and paragraph 12. Appearing for the state sovereign, this is the which has been argued, and ultimately, my lord, the finding the law shall find paragraph 12. My lord is looking paragraph 11.
9. You
Nine.
said 9.
Yes, it is a submission of the state
Yes,
now.
yes.
It is not dispute that it became the lowest bid in connection with the earlier NIT. The appellant's bid was accepted by the authorities by later dated such and such. The later contemplated execution of a normal agreement between the parties. Such agreement was fact executed 24 December 2013. The agreement did not stipulate the period of time for which the same will be valid or be enforced. That cannot mean the parties intend that the agreement should be valid for an indefinite period of time. However, an indication of the validity period of the agreement is there in the later dated 20th December 2013. By the respondent authors, where it mentioned that the rates approved by the authorities will remain valid from the date of this said letter till 20th December 2015. Thus, it would be reasonable to conclude that the agreement between the parties died a natural death upon expiry of 20th December 2015.
What is the basis of this date, 20th December 2015?
Yes, after the 3 years directed to be continued by later date 20th December.
By a letter, there was a letter.
Subsequently, initially there is no time frame.
Subsequently, parties agreed to that.
And here, the contract itself included that the contract is till February 2021. Then how, my lord, even assuming, my lord, I have not withdrawn the earnest money.
What is the balance period left, Mr. Rai?
Over 2021 and this is 2023.
No. I'm asking you the balance period of your serving in the Panchayat. How much time it's spending?
Online, otherwise I'll submit my lordship 2.5 years. Then there will be a change automatically. Because this is the points of law, my lord, which, though I did not participate, there is a direction to file reinstatement with the payment of 5,000 rupees. There is a dispute going on against the presiding officer. My lord knows that Ghatal, that is going on. I could not deposit, so court proceeded ex-parte. So I cannot place anything other than the documents which they have relied upon and taken into consideration for the same.
The opposite party number 1 is restrained by an order of permit from declaring the election as valid.
This is the election commission.
Yes, but the election you had declared as.
Yes, my lord, if it is held to be void, it is, my lord, kindly considered that way. So natural death requires any further communication or not?
The
So dated 21/2021, reference NIT number. This is the question issued in favor of.
Show me the work order. Yes, that is the only thing.
Right, work order, my lord. At this point of time, they can also produce the work order. It is
Yes,
their
37, yes, 37, it is produced.
7.
It is their writ application, it is recorded. In their writ application, it was recorded. Going by the time schedule. Yes.
My lord, it has not been completed prima facie, and they have not challenged this. My lord, the competent authorities have state till date the work order is subsisting.
So what is the period for this contract? Show me.
Going by the time schedule mentioned in the work order dated 20th January 2021, the contract ought to have been over by February 2021. This is a specific finding of the writ court upon going through the work order.
My lord, the writ court, my lord, have not decided that issue, my lord, the coordinate bench.
Yes, what is the time schedule? Show me the time schedule.
Time schedule.
The contract cannot be unending for the unending period. It's for construction of a pakka drain.
Pakka drain, my lord.
Yes, and there is also
not done.
there is also a provision for penalty in case of failure to do the stipulated time. What was the stipulated time? Cannot be an unending one. Pakka drain construction.
At that point of time, 2023, it was not completed.
Sir, there are two things. There must be a period. Now, let us assume a case. You have been awarded a contract, work order, and you have been asked to do that contract for within a certain time. But there is no other letter terminating. Will it continue for years together?
May I answer, my lord? In my
Yes.
My lord, a contract.
Show me the time period for this contract.
The work order does not say any time period.
Then,
my lord, if there is a time period, let the petitioner shows there is a
Page
time.
37, I am relying upon that. No. Page 37, their application, it was recorded by the coordinate bench.
That document which was produced was a fraudulent document that was, my lord, negated by the learned court below.
This is work order. Work order dated
That there was a specific time period fixed. And my lord, kindly see the conduct of the petitioner, how the petitioner has proceeded with this litigation. Only intention is to delay so that to make the entire election petition infructuous.
but Mr. Rai, where from this finding was made?
It was
It appears that the time schedule for completion was 30.
the learned from the state in the writ application. Yes.
State is also a party here.
They are also party.
Who is appearing for the state? Have you served it?
No, my lord, there is caveat of my learned friend, that is why I serve.
We serve upon the state. Otherwise, that is the only.
That I serve, my lord.
That is only the issue.
That is the only issue I have before your lordship.
Yes.
And I want to draw your lordship attention, kindly turn to page 40.
14.
40.
Oh, 40.
Yes.
Yes.
This is the registration of the petitioner. Your lordship will find this is up to 2021. My lord will valid year. My lord got it.
2020 to 2021.
Last year renewal was not done. Need to be registration again.
No, Mr. Rai, that is one thing.
That is one thing. Only the court proceeded the existence of the contract of 2021. Page 12, your lordship will find this is the findings. Exhibit 15.
Let this
page.
and say that the contract
Exhibit
was not
15.
subsisting. There is nothing remains, my lord.
Page 12.
It come and say contract was not subsisting.
Page 12. The findings of the court below. Considering the documentary evidence of record and view of the citation referred
of the impugned order.
impugned order, my lord.
Yes,
This
yes,
is the
also
only
there.
documents.
Yes.
This agreement is that the respondent number 6, who was the proprietor of Nosip Council, got work order number such and such, dated 20th January 2021, whose NIT number is 6, memo number such and such, and serial number 3, then said work has not yet been completed. So this is the only work order basis on which this adjudication has been made. I have to prove before your lordship that the existence of the tenure of the order is up to February 2021.
And let state come and say that the order contract was not subsisting. The matter ends, my lord.
But here it's the finding. What was the, this is the exhibit. What was the exhibit number?
15.
15. Where is that?
That the documents because I have not participated, I cannot get back to. I have not participated. There is a direction I have directed, unable to pay that amount. That is why I have been debarred from participating in the process. It is expert. So I have to rely upon the documents which my
This honorable court has directed the petitioner to deposit 5,000 cost within a specific time and participate. On that day, on 3 occasions, the
No.
petitioner did not.
and I have,
Accepted.
so I have to rely upon.
Yes. Where is that document? Where is that document?
Exhibit 15.
Exhibit 15. Because Mr. Rai, there is a finding of fact.
That is why, my lord, I have to produce the work order.
Yes, that document exhibit 15
is, my lord, letter addressed by me by the Pradhan 1 Gram Panchayat. Whether that's can be page 5, you should find the tabular, page 5 of the order impugn, the exhibit list as you mentioned.
Page 5, yes.
The letter addressed to
me, letter addressed to me by the Pradhan.
Yes.
That is you, letter addressed to, no, it's him, by the Pradhan.
Yes.
Dated, yes, where is this letter?
Yes.
This was addressed to you. Show me that it clinches the issue.
No, it will not clinch the issue because, my lord, the subsequent letter that your lordship will find at page. এটা কোথায়? এই যে and turn to page 39.
What is 39?
The process as usual. He asked for a letter given, and this is the letter given to me when I came to know.
Let state come and say.
Yes.
Mr. Rai, please serve upon the state without this.
Or election commission or the state, because both are standing on defined footings.
Yes, both you have to serve.
My lord, I am paying. I am vacuum in the office. My lord, can you consider today, my lord?
Yes, I'm keeping it on Monday. Please serve upon them.
Can it be on Tuesday, my lord?
Tuesday. All right. আচ্ছা আগে কি বললাম? Move before the vacation bench, no.
I'm retiring from.
You have that grave urgency, Mr.
So I am before your lordship.
Yes, yes. এই বইটা দিয়ে দিন।
May
Item 25.
may I take back or
What is that?
the
Judgment?
Yes.
Take it back, produce it on the next. মশা নেই দেখি। ওই উপরে দিকটা বলতে। Yes.
Now, the decree holder is a petitioner before your lordship. Now, suit for eviction on the ground of default, lock and key, and reasonable requirement. The order impugned is not allowing an application under Order 9, Rule 13. But I shall. Not that there are not really, but before your lordship, Order 9, Rule 13, I am placing not there are certain grounds. Not I shall place before your lordship. Kindly once looks at the observation of the learned judge directly, because not the ground was being taken. There is a Section 5 application. It is not a case of non-service of summons. Service of summons was made.
Mukherjee, you do not have a good case on merit.
No, I have better case on merit because 7172 filed belatedly without compliance with 71.
Better, Mr. Mukherjee.
Why, Milord? I am not even
when the
I will
decree
say-
was passed.
Milord, the ex-parte decree that was passed on.
Yes, there is a caveat. No.
Caveat, yeah.
No caveat, yes.
Milord, the ex-parte decree 18th April 2023.
18th April 2023.
And the Order 9 Rule 13 application was filed on 19th of April 2024.
Order 9 Rule 13 with Section 5.
With Section 5, the delay has been captioned to be of 32 days.
From the date of knowledge.
It is not a case of non-service of summons.
From the date, they have said from the date of knowledge.
From the date of their knowledge of the execution case. That is their case in Section 5, Milord.
Yes.
The court is also not oblivious. The court said why you have quantified the delay like this. Article 123 is very clear. If it is a case of non-service of summons, then from the knowledge. Milord, kindly takes up Milord, the order impugned once. Milord, I will not trouble your lordship entirety, only a portion of the order. Milord, if your lordship takes up Milord, internal page 3. Right? Yes. Internal.
Internal page 3 of the impugned order.
Impugned order.
Yes.
Kindly takes up the second paragraph of internal page 3. So far, Milord,
already you serve.
Milord, only Milord, the stay of the Milord suit. Stay of the suit
has to be done.
Yes. I am praying for that. Lord. I being the Lord decree holder, I am praying for that. Lord, I will show before your lordship the court, one of the observation kindly once looks at one last but one page of the order impugned.
Mr. Mukherjee, your suit will be disposed of prior to the civil division.
Why I am saying, Lord, kindly takes up Lord, this.
I can
This
expedite the
observation should not remain even on record. The learned judge Lord is saying, Lord, last but one page. Kindly takes up last but one page.
Yes.
Ground has been negated. Kindly scrolling, last paragraph of that page. Scrolling on the path of the above discussion, this court has no hesitation in its mind to hold that the petitioner has miserably failed to prove any ground for condonation of almost 1 year delay and the restoration of the suit, allowing the petitioner to contest his right. All the grounds stated by the petitioner appear to be vague and baseless. And thereafter, Milord, and a longish discussion that Section 5 delay not quantified, advocate latches could not able to prove. Financial stringency could not able to prove. All findings are in my favor.
You want a much cost of a higher amount?
That is not. That is also not.
According to you, a paltry amount has been awarded as cost.
Now in 2025, Lord, the Honorable Supreme Court has made it clear what is Lord, the just and reasonable cause for condonation. That has
no. I'm not saying
no.
cost.
I understand.
I'm saying
no.
Cost. This is not a reasonable cost according to you.
I'm on merit.
Mr. Mukherjee. to your motion. The matter when you will be coming to move a motion,
It will become
I will
instruction.
take it up just prior to that, with that understanding.
And I have one Kaliga. That is the prayer I can make. Only this is the point. Everybody is. If I can produce a work on a particular day,
ফরওয়ার্ডে রেখে দিন তো ওগুলো বলবেন 4:30 পর।
My lord.
No, Mr.
Item number 26.
Yes.
On behalf of the plaintiff petitioner, I am praying for expeditious disposal.
কি বলেছিলাম আমি আমাদের সব জানে। Yes. What do you want?
I am praying for expeditious disposal,
Of suit.
my lord.
What are the pending applications?
Injunction application, my lord.
Injunction pending.
Yes, my lord.
This application under Article 227 of
Item number 27.
yes.
27, Mr. Bhattacharya is appearing.
Since I'm
I appear for the opposite parties. There is a caveat, Lord, I have served. It actually
yes
recorded. সেটা পরে লাস্টে দিস Lord, here, Lord, my application for amendment of plaint prior to commencement of trial, when the injunction application has not yet been heard out on merits, is being turned down. Similarly, Lord, I applied for amendment of injunction apropos to this, Lord. That was turned down at the initial stage. I came up in revision. Your Lordship admitted, Lord, the revisional application that is pending.
yes, what is the suit for?
Yes, Lord, kindly takes up, Lord, the plaint, page 11 of my Lord's brief.
Yes.
Lord, there is a conveyance executed in persuasion of mine, wherein, Lord, the person Tulshi Shaha, who sold the property, he happens to be one of my relative, and kindly takes up paragraph 3-4, and it has been negotiated that since the Tulsi Shah is being executed the deed much lower than the market price, subsequently an agreement
File a suit for declaration.
No, I'm coming, Milord. What kind of declaration? Milord, I shall.
No,
There is an agreement. Milord, I am just placing before.
Yes.
There is an agreement between the defendant and the plaintiff that since I have persuaded my relative to sold the property to him much lower price than the market price, there is an agreement executed between us wherein they, being the developer, has agreed that 30% of the developed area will be handed over to me in that agreement. That is 11th November 2013. Kindly takes up now the prayer.
Yes.
Page 22 of my lord's brief.
Yes.
It's couched in the manner of declaration, but asking for specific performance, not subject to correction by my lord. A decree for declaration against the defendant pursuant to the agreement dated such and such made between Tulsi Shah since deceased and the plaintiffs being entitled to 30% built up area of the construction made and erected at the suit property. The defendant as legal heirs and heiresses of such and such are liable to sign and execute necessary documents showing specifically demarcating 30% of the said constructed area. So really, my lord, asking for specific performance of that agreement, but in a form of declaration. What happened? My lord, my suit is not being valued properly because, my lord, it has to be, my lord, at the market price. That's why the amendment comes in. Kindly takes up now the amendment of plaint at page 44 of my lord's brief. Admittedly, this amendment, my lord, is prior to commencement of trial. Injunction application is still pending. Page 47 of my lord's brief is the schedule of amendment.
Yes.
First portion, valuation statement, my lord has got.
Yes.
Now, my lord, point number E, page 9. My lord, the said agreement, what the plaintiff is entitled to decree for specific performance. So instead of declaration, the specific performance is being incorporated. 30% other thing remains same. And the prayer portion at page 50, my lord will get, my lord, a prayer is incorporated a decree for specific performance of agreement dated 11th November 2013. Has your lordship got it, my lord? So if it is really not changing the nature and character or parte, not the texture of the suit, the next point the learned trial judge, my lord, has already noticed that the point of limitation.
Yes.
Kindly takes up whether it is expressy or not. Kindly takes up once paragraph 11 of my plaint, original plaint. Page 15 of my lord's brief.
Yes.
So, my lord, it's a 2013 agreement. I'm sorry, my lord. Paragraph 15.
Paragraph 15.
Sorry, my lord. Page 15, paragraph 11 of my plaint.
Yes.
Kindly see, pleaded that admittedly pursuant to that agreement, ultimately the sanction plan was being obtained in 11th December 2021. Has your lordship got it?
Yes.
Now, my lord, paragraph 12, when the death occurred of the original, my lord, the original, my lord, the developer, 6th March 2022.
Yes.
My suit is of 2022. My amendment application amendment date to 1 hour.
Amendment application filed when?
Not in any event, 2022 suit, not the
Fifth February 2025. Right, that's what page 5.
6th
February 2025. Page
25.
Page 5.
Page.
Page 5. Page 5, paragraph 8. That's there in the pleadings.
Oh, achha.
In the civil division application.
It's clear and
That is joint written statement filed.
Took out 2 applications under Order 6 Rule 17 of the Civil Procedure Code on 5th February 2020. Para 8.
Para 9. Oh, yes, 8.
8.
Yes.
So I say, my lord, my prayer for specific performance was inbuilt in the suit, filed in 2022, well within the period of limitation, not couched in the language of specific performance, but in the form of declaration. So it is nothing but, my lord, a explicit change of, my lord, the part, say, my lord, the prayer made, which is made in the form of declaration, now specific performance. I just want to quantify my suit by giving a proper valuation.
Yes.
And Milord, in the same line, Milord, an application for amendment was being made in respect of injunction application also. That was turned down at the very day. And Milord, your Lordship has interfered with that order, Milord. That is page 63. A separate revisional application has been filed by my client in respect of refusal to injunction application in the same tune, which was done earlier. I filed the revisional application. This order has been passed. Subsequently, this order has been extended also.
That is amendment of the injunction.
Injunction, yes.
So this was not by the same order.
Not by the same order, because on the very day, my injunction application amendment was taken up by the learned judge and rejected threshold. But order 6 rule 17 was kept pending in respect of plaintiff is concerned. That's why your Lordship also made it clear that, however, made clear that pendency of the application under Article 227 shall not preclude the learned trial judge in taking up the hearing of the interlocutory application. By your Lordship's order, it has been made clear. That's why now my injunction my application for amendment of plain comes up and rejected by the order impugn. I say both ground is not tenable. It is not changing the nature and character of the suit, and it is not an expressive barred claim, Milord, is being incorporated by UF amendment.
Yes, come after 2 p.m.
After 2.
Yes.
Your Lordship, may I be permitted to mention a matter, Your Lordship? The day before Your Lordship was pleased to release a matter, Your Lordship. Your Lordship, I'm seeking one indulgence, Your Lordship. I will have to get it assigned before the appropriate bridge, Your Lordship. I'm humbly praying before Your Lordship to direct the department to upload the order, Your Lordship, during the course of the day.
Just call the list, judgment.
Deeply obliged.
Item number one, my lord.
One for the petition.
In view of the aforesaid discussion, this court holds that the order yes.
Grateful,
Thank
my
you.
lord.
Yes.
Item number 28.
Okay, doctor. Yes.
I guess my learned senior friend is.
But yes, no, I have concluded.
Two things. One is this is a suit for declaration. What they are seeking to do is convert it into a suit of specific performance. Lordship will know that the suit in the specific under declaration was filed with the court fees was valued. Now a right under 711 has accrued to me because the suit is undervalued. Now if they
Did you apply under order 711?
I had applied. And the order was it's a mixed question of fact and law.
Rejected.
We will take it. And the second point, Lordship, which
that was prior to the amendment.
That is prior to the amendment. And the only predicament here is, Lordship, this is a suit filed in the junior division. Now, subsequent to the amendment, they are wanting to value the suit at 84 lakhs. So the jurisdiction of that court gets ousted. Lordship knows, Lordships have held the proper procedure would be to allow the amendment and return the plaint back so that appropriate steps can be taken. So in that occasion, if that falls from a Lordship, then we can proceed on that aspect. Because Lordship, what will happen is if today the suit is allowed to be amended, then the court will lose the jurisdiction.
Yes.
And they'll have to come back and take it afresh in whatever jurisdiction the court is, whatever determination, which would be the senior court, senior division. So if to that extent, if it falls from your Lordship, then as an officer of the court, I would not have anything to say. I'll bow.
That's the procedural part. What you have to submit on the merits of the amendment.
The amendment is that first and foremost, Lordship, it is a declaration, the suit for declaration. They have not sought for a specific performance. And now, my humble submission was that the changing a suit of declaration to a suit for specific performance
is not permissible.
Ex facie changing the character and nature
character of the suit.
That is exactly, Lordship. Nature and character is again, Lordships have held, it's your Lordship have to look into the facts. Now, Lordship, here I file a suit for declaration. And then I want to change it to a specific performance. And that is primarily the reason why the court by the impugned order has rejected their application. Their application for amending the order 39 rule 1 and 2, which got rejected, which they have come up before your Lordship, Lordship has granted them a stay, is not changing the character of the plaint. So maybe that is on a different footing.
No, I could not follow your this
Lordship,
submission.
they have annexed and they also showed an order passed by my lord, where my lord has.
So that is the injunction.
Absolutely, Lordship. That is a different footing.
Yes.
But here, Lordship, the nature and character comes from the very first title of the plaint. The plaint is a suit for declaration. And now, Lordship will kindly take a 47. Lordship,
Page 47.
Page 47.
Yes.
Or Lordship, just kindly bears with me, just kindly takes a page 111 once. Or it a kon page hai? Page 12, my lords.
Page 12.
Page 12, just page 12.
Yes.
Lordship kindly sees the nature of the suit. Suit for declaration, mandatory and permanent injunction, suit valued at 150. Being rupees 100 for declaration and rupees 50 for mandatory and permanent injunction. Lordship, by the schedule of amendment, she will kindly take a page 47. And Lordship sees what they're intending to change. Lordship, A, I'm reading out the part, Lordship, suit for specific performance of agreement dated 11th November 2013 and declaration and permanent injunction and mandatory injunction. Changed. I understand it is pre-trial. And Lordship, by this, they are also seeking to enforce an agreement of 2013. What stopped them from doing this in 2022 when they preferred the suit? If they have couched it in that manner, they have not in their application, even in one word or one statement as to what prevented them to not use this. They could have given some reasons, saying that maybe the lawyer did not appoint the usual that we give, my lords. Nothing has been said. So the application, the bona fide also has to be looked into. They are changing the complete nature and characteristic of the suit. My 711 stands rejected, but I should be candid. My 711 was filed under 7A and 7D. The point of undervaluation 7B was not taken up in my 711. But that doesn't preclude me to take this point up at the framing of issues, my lords. I could have taken it up at the framing of issues. I could have. I'm not saying whether it would be allowed. I could have. A right had accrued which I could have taken.
Anything more?
That's
Yes, Mr. Mukherjee, anything in reply?
Paragraph, page 45, paragraph 4. My learned friend says, I have not given any explanation, though it's pre-trial amendment, but page 45, my application starts at page 44. Paragraph 4, my lord kindly looks at which exactly I have submitted before your lordship.
mention any day.
যে কালকে ফাইলটা কোথায় আছে?
The service is kept up.
Grateful.
Grateful.
Just call the next matter.
Matter number 29.
I pray for expeditious disposal, Lordship. The petitioner is the plaintiff in the title suit, Lordship. Filed in the year 25th of May 2019. Till now, Lordship, issues are not yet been framed. The next date is now on the 22nd of December 2025. There's an order 39 rule 4
Order that rule 4 by the opposite party.
opposite party filed in
You
20.
you are the plaintiff.
I am the plaintiff, Lordship.
This application under Article 220.
Matter number 30.
Yes.
I cannot lose both the matter in a single day. Could you self allowed in relation to joint position?
Who is self allowed? Joint possession.
And yes, super partition. Admittedly, in the plain dictionary mentioned we are in joint position.
Yes.
Police have directed that restraining the defendant from interfering with the
Right.
encroaching.
Now
I can lose both the times once. Servant cannot lose, my lord. Can I consider
it's identity or temporary.
identity? No. Now can you consider the in order of injunction?
Yes.
That
So
order of injunction.
you are the defendant of the plaintiff.
Defendant. Before that, my lord, I turn to page 23 once.
23. This is the application.
Application. That paragraph 4.
Yes.
Before that, there is a share of giving into the subsequent settlement that subsequent share of the suit property transfer interest such as a suit property in a positive share jointly with other co-sharers of the suit plot. My lord, got
Can to possess his respective share jointly with the who is Bakkar? Bakkar is the plaintiff. No.
Yes. No. The entire share of Bakkar Mondal and got the property Bakkar Mondal began to possess the plaintiff's predecessor.
Plaintiff's predecessor is Bakkar.
He, along with other co-sharers, according to them, jointly.
But during his right title and interest joint position respectively, died leaving behind Chattar Mondal, Abdul Aziz. They are the plaintiffs.
Yes. My lord, it was so admittedly on the basis of joint position. Now, my lord, can I turn to application under 151, page
So,
31.
the injunction order.
The status quo.
That
The
is
nature, character, and position is mentioned in the application itself.
No, you have not annexed the order.
It is not with me, my lord. In their application, I'm on their application, page
But,
31.
this is with regard to this order of injunction.
That was considered. Trial court, I have royal lordship decision. Can you turn to page 31? Application for injunction, police.
Yes.
Status is the nature, character, and position of the suit property as well as the plaintiffs are possessing the suit property by cultivation.
Paragraph, which paragraph?
Paragraph 1, your lordship will find.
File the suit for partition along with an addendum and preparing status quo as regards the nature, character, and possession, whereas the plaintiffs are possessing. What is the meaning of these?
According to
Whereas
them,
the
the
plaintiffs are
status quo was
possessing.
directed, plaintiff was cultivating, but we are disturbing him. So by way of status quo, it should be implemented. Now, my lord, apropos to this, my lord, can you turn to the application has been disposed of the order impugned. This is 9/9/2025.
Yes.
Next order 30 rule 1 and 2, my lord, got it? Middle
Yes.
portion.
Next is this is order 30 rule 1 and 2 is taken up for hearing.
Everything. 3 petitions.
All right. So is directed to maintain status quo regarding both the parties.
Both the parties. So
Now,
this is the
show me the finding that both are in possession. Considering I find that
this is the
stage,
disposal order.
is that both the parties, I find at this stage, both the parties are co-sharers. Rest of the contentions, I'm unable to accept the contention of the defendant entire.
Since it appears the stage of co-share, I think that they have privacy right to protect their position in the suit properties at this stage against any kind of forcible disposition. In this way, I think that the plaintiffs have good privacy case in their favor at this stage. I also find that if the defendant number 1 were allowed to encroach the portion of the suit
You
property,
cannot encroach, Mr. Rai.
well, encroachment, one co-share's property.
What will happen? You will not be prejudiced. You are not encroaching upon. Both of you will. The police will go and see. How are you?
I think finance is given by your lordship at 2.
You have not seen the findings, only the operative.
Well, at least, well, yes. Now, both the parties are maintained as we get position of the suit property is mentioned in the sheet of the established as on debt till the disposal of the suit. Now, my lord, kindly consider 151 application. Does the
Hence, OCPS is directed not to obstruct the plaintiffs.
yes that
OC will not obstruct. It's in your favor, Mr. Rai. This is the order.
Well, can you consider this? Thus, the interference by the police personnel at this stage is absolutely uncalled for. So, their application for police help. OC Thanawal is directed not to obstruct the plaintiffs from cultivation their portion of the suit properties. OC is further directed to ensure that none of the parties disturb the peaceful position of cultivation respective portion of the in possession of the.
This was ex-parte or in your presence?
It is in my presence. So,
what was your objection?
They are not. There is objection page 33.
33, yes. You are also cultivating. What?
Yes.
Show me that.
Yes. Paragraph 4 honors. The above reasons the injunction in form of status quo cannot be sustained in law. Moreover, the order itself become bad in law. Position of the plaintiffs with the entire property cannot certainly be identified, and therefore regarding necessary police help cannot arise because he is claiming to be share of the particular share of the property. That it is not possible police person determination portion of the plaintiff's position with that the land in suit. The essence of the petition, it comes to light the plaintiffs are praying for injunction against the police person, and therefore plaintiff petition become infructuous. Such as totally false concrete images say plaintiffs were detained for more than 8 hours in the Thanawal police station. So this even if Balakari consider, I am saying that we are in joint position. A super Need not to go to the police court. We have to approach the local police station. It will done everything from there.
Yes, call the next matter. কবে আসবে? Yes,
Well, pendency of this division is not a stay for the suit may be proceeded in accordance.
I've not passed any order of stay.
Why, madam? They are suit for partition.
Uh,
In a court, it can't fall.
It is however made clear without saying it does not require any recording.
My lord is saying, my lord is forgetting this side, my lord, quite a long time. My lord is on that side.
No,
That-
Mr. Rai, you have,
My lord, Kali, in the
you have-
paper, we used to know what will be the first letter, the second letter, third letter.
yes, call the next matter.
What-
Those days are gone, Mr. Rai. Cannot. Yes.
20 foot. Preemption application was under Muhammad Ali. Preemption application under Muhammad Ali.
It's a suit.
Suit. And Lord, what happened, Lord? The
Now, what happened?
Lord, in the argument stage, the application was made to examining two witnesses, Lord, regarding proof that the second stage of the preemption, Lord, in which, in presence of the witnesses, the preemptor declares that I want to preempt this matter. Lord, there are four stages. Initial, Lord, just after information will jump up and say that I will preempt. Second stage, Lord, in presence of the one of the purchaser of the defender, the purchaser or vendor, and Lord, the two witnesses, at least two witnesses, he will say that on jumping, he will say that I will purchase the property. Next stage is not for whether he has capacity to purchase the property, and third stage, Lord, this limitation within a year and entire property sold has to be purchased. That is the Lord, so far while giving evidence, but the witnesses too who were present, those were not examined. Lord,
witnesses who are present were not examined.
Who were present at the time of exercising the second stage, Lord, they were not examined. But matter was fixed for argument. Defendant's argument was complete. Thereafter, this application was filed. This has been rejected on the twofold ground, that is delay and Lord for filling of latches. But it can be done, Lord. Your Lordship kindly see there. And paragraph 7, Lord, of the plaint, it has been pleaded specifically. Now, kindly see. Now, kindly see the order.
Where is your application?
Lord, application has been annexed, Lord.
Paying for adducing further evidence?
Lord, can you take at page 20?
By the order impugn the prayer of the yes.
I'm for the petition, Your Lordship.
Yes,
My lord, I will not take much more time before vacation, Your Lordship.
yes.
You know, the fact of the case is that, Your Lordship, the petitioner before Your Lordship is the plaintiff. Originally, he is a tenant, and original died upon the death. Their heirs sold the property to the promoter. Now the tenant and promoter entered into an agreement about the 460 square feet. They will hand over after taking the full construction. That is the agreement. But one clause is there, that is the dispute, that clause number 5. Kindly come to the page 11. Annexer A. This is agreement, but I'm not pressing the enter. Kindly come to the page 14, paragraph
What is the
5.
impugned order? What was done by the impugned?
Yes. Kindly come to the page 40.
1-4.
4, paragraph 5. I'm not pressing the enter, it's not necessary. The paragraph 5, the 5th line. দ্বিতীয় পক্ষ যতখানি বর্তমান রুম বিশিষ্ট জায়গা ভাড়া প্রদান করেন সেই পরিমাণ 460 বর্গফুট জায়গা রোড সাইড বরাবর দক্ষিণ পূর্ব মুখ পাইবেন, ইহাতে প্রথম পক্ষের আপত্তি থাকিবে না বা অগ্রাহ্য হইবে, থাকিলেও তাহা অগ্রাহ্য হইবে। উল্লেখ্য, যদি দ্বিতীয় পক্ষ প্রথম পক্ষের নিকট স্বাচ্ছন্দ্যতার জন্য বর্ধিত স্কোয়ার ফুট অনুযায়ী জায়গা দাবি করে, তবে সেক্ষেত্রে প্রথম পক্ষ বিবেচনা করিয়া বাজার মূল্য বর্ধিত জায়গা সম্বলিত রুমের ব্যবস্থা করিবেন। If I claim, then I have to pay as per market price. If I not claim, my lord, there is no question of market price. Therefore, if I claim that part is beyond the agreement, if I claim that portion is beyond the agreement. Agreement is concerned about 460 square feet, and kindly come to the paragraph. Page 18. That is the schedule. The same identical 460 square feet. Ground floor 460 square feet. Now, my lord, kindly come to the page 74. Page 74. Initially, I got the interim order, page 74.
Yes.
Yes, page 17, the prayer for interim injunction order is considered and allowed ex-parte. Therefore, initially, I got the injunction to share the suit property. Then, my lord, kindly come to the 63. Page 63, their written statement. Page 63. My lord, may I read the paragraph 7?
Yes.
That the statement made in different paragraph claims are not admitted to be true. Statement made in the plain in the effect that defendants are powerful and so, and evict the so. Next, my lord, can you come to the next page? Defendant have not allotted flat on the ground floor to the plaintiff and the said activities, and my lord, absolutely, and kindly see the last line, absolutely false and hereby denied. Therefore, my allegation is that they are not handing over, they are saying no expense. And kindly come to the next paragraph, paragraph 10. As per the condition of the agreement with so, plaintiff is entitled to 460 square feet covered area, specific description as mentioned in the said deed of execution. They admitted that I am entitled. And then we will not kindly come to the page, next page, paragraph 13. For that, the 460 square feet flat of the plaintiff is suit property is still lying vacant. All others are occupied for different, and this is not necessary. So, my lord, this is the admitted position. My portion is lying vacant, and they are ready to take over my possession. Only as regard to the actually at the time of construction, my lord, they made the construction beyond the 460 square feet. Now they are creating the pressure. We have to pay. They are saying no, 460 square feet. And my lord, kindly come to the page 69, another admission, that is written objection. Page 69, paragraph 11. The 460 square feet of flat of the plaintiff suit property is lying vacant, and therefore, my respectful submission is that the defendant that deny or interested to deny the plaintiff right. Until the defendant deny or interested to deny the specific performance under section 34 is not applicable. Why not? Kindly come to the page. Kindly come to the page. My lord. Kindly come to the page. Yes. Not kindly come to the page 82. Under such facts and circumstances, last paragraph. The plaintiff file a suit for permanent and mandatory injunction because as this claim is based upon the terms and condition of the contract so and so, he must have filed a suit for specific performance of contract. The specific performance, this is elementary. May I place the section 34 of the specific performance act? Deny and interested to deny. This is elementary of the section 34. Until and unless they deny and interested to deny, may I handle the book of the specific section 34.
This is you place, yes. Yes.
Any person entitled to any legal character or any right as to any institute a suit against any person denied or interested to deny by the defendant until and unless they are denying the specific performance suit is not maintainable. There is suit for mandatory injunction or permanent injunction. Exactly what you have made. Kindly see my plain. Kindly come to the page 44. Pair I. 1. Pass an order of permanent injunction, it should be the degree, restraining the defendant and their agent to sell out the suit property mentioned in the suit. And what is the ground of rejection? They are saying, and the first miscellaneous appeal, the senior division affirmed the order of the junior division. What is the ground? Because this is a case for specific performance of contract. Not section 34. Because they never denied the plaintiff has no right, plaintiff has no interest. On the contrary, they are saying, we are interested to hand over. With regard to the extra was done by the defendant, they paid money as per the market, and they are saying we don't have the money. And that is totally beyond the scope of the agreement. Not within the scope of the So, my lord, the concept and totally notification of the judicial mind of the learned junior division and the senior division. Total non-application of judicial mind. This is the elementary. There must be the deny and interest of the denied. Is there on the contract managed by affidavit they have said we are interested to hand over that portion subject to you have to take this extra portion we have made. That's the dispute.
Why are you not paying the extra portion amount?
Right. Can take better amendment. And problem is that because they have concealed my lord as per the agreement 50 square feet. 500 or 550 square feet.
What is the relief you want in the suit?
Page 44.
Page 44. Not to sell because they have not denied. So
No, not to.
Then the suit property.
So that cannot be a
And mandatory injunction to act on the basis of that agreement.
mandatory injunction to.
Act on the basis of that agreement.
This is the mandatory injunction you have sought for.
Injunction directed to execute the registered deed.
Yes. So this execution without specific performance can be done by mandatory injunction.
No, the provision is very clear. Interest and interest denied to interest. But there can be
Mandatory injunction is since they are denying you have sought for mandatory injunction.
no, my lord. Only our dispute is that as regard to the extra portion was done by the promoter.
Let us forget about the
Yeah.
hold the pair. Nobody is stopping you from holding the pair.
But this does not mean, my lord, they will deny the.
Please hold the pair, file an application for amendment in the court below. It's a different thing altogether. Molding cannot be done here. Molding cannot be done here because in effect what you are seeking for mandatory injunction is to bypass paying of the court fees.
No, you paid. We have paid the court fee,
How much?
but actually, no, the food ballot is 509.
Cannot be. What is the valuation? Specific performance cannot be valued at 500. That is why I am saying, in order to avoid payment of correct court fees, you have couched your claim as a mandatory injunction. There are
So, my lord, may I submit one thing, my lord?
decisions on this point. It has been.
May I submit one thing, my lord?
Please amend your plaint, otherwise.
No, my lord, no, my lord, may I let me,
7 Rule 11, madam.
let me present. But they may not give the liberty to the plaintiff. And then the prayer of the, my lord, no, my lord, no, my lord, problem is that, my lord, injunction is required. My lord.
Not at this stage. Ashun.
Comments, my lord.
Filing department return this file due to this problem. I am paying for unconditional apology. Filing department return this file due to
Why?
some.
What have you done with the certified copy? Where did you keep it?
This copy come from the Lalet code below. That's why.
Where did you keep it? Yes, Mr. Rajodri, please see the certified copy.
Kindly, your lordship.
What did you do with the certified copy?
Code balance.
But it was there.
Read it. Kindly, otherwise, lordship leave.
Yes, call the list.
Item number 33.
My lord, my application, my lord, for expeditious disposal of my order 39 rule 1 and 2 application, my lord, pending before learned Rajarhat commercial code, my lord. My lord, I should indicate, my lord, previously we have preferred an appeal against a refusal of ad interim ex-parte, my lord. That appeal court said that nothing to interfere in this. So, my lord, now the pleadings are complete, my lord, in order 39 as well as in the shoot, my lord. So, may kindly pass an order of direction on the court to take out the matter expeditious, my lord.
What is the next date fixed for injunction?
My lord, the next date fixed is, my lord, 10/11, my lord.
Written statement filed.
Yes, my lord.
This application under Article 227 of the Constitution. Yes.
This I am only paying for early hearing of the early disposal of the appeal, which is pending before the.
What is the appeal?
What is in this? This is a appeal from an order of eviction, which has been passed by the.
Who are
court.
you?
I am the plaintiff respondent. I am the plaintiff respondent, and I am the
But there is
respondent in the
a
appeal.
occupation charges, area occupation charges was directed to be paid by 5 equal monthly installments. Is the period of monthly installments over?
Yes, they are paying.
They are paying.
They are paying. They are only monthly. The property location is at
Application under
Sorosmouth
Article
Road.
227 of the Constitution of India is at the instance of Yes, Mr. Haldar.
The plaintiff landlord is the petitioner before your lordship. The suit for eviction. Suit decreed ex-parte, my lord.
Suit decreed ex-parte.
Ex-parte. Order 9, Rule 13, filed. In connection with the said Order 9, Rule 13,
This is for default.
defendant filed an application for injunction restraining the defendant from changing the nature and character of the suit property. My lord, initially
I could not follow. Order 9, Rule 13, filed.
In connection with the said miscase,
Yes.
defendant tenant filed an application for injunction restraining the opposite party, that is the landlord, from changing the nature and character of the suit property and from
possession.
Yes, my lord.
Say so. That is why I
Also
was.
from demolishing the structure. My lord, my lord, initially, my lord, I did not appear in the said miscase, and said miscase was posted in the ex-parte board. Subsequently, my lord, I appeared, and my lord, I took out an application for vacating the ex-parte, vacating the order of ex-parte hearing of the said miscase. And my lord, I also filed an application for SOCOS. All those applications are allowed. If you will also kindly have a look at page 22.
Now, what is the impugned order?
Coming, my lord. Kindly have a look at page 22.
Yes.
Middle portion, upon perusal of the record as well as the petitions filed by the opposite party, it appears that due to non-appearance of the opposite party, the case was fixed as ex-parte as against the opposite party on 29th April 2024. The opposite party has appeared today and filed a SOCOS petition, and the grounds mentioned in the SOCOS petition is found to be sufficient. As such, the SOCOS is hereby accepted with cost of rupees 1,000 and for vacating such and such. And my lord, the opposite party was allowed, my lord, to file written objection to the same. Well, a similar application was filed, my lord. By this time, my lord, the application for temporary injunction was disposed of prior to my appearance in the said miscase. I took out causing similar, showing similar cause for, my lord, recalling of the order of injunction. Kindly have a look at, my lord. Kindly have a look at, my lord, page 26. Page 26.
Yes.
Today is fixed for hearing in this case. The learned advocate for the petitioner has filed Hajira, affairs focal number along with an application under Order 39 Rule 4 CPC and application under Section 151 for rendering police assistance, copies duly served. They took out an application under Order 39 Rule 4 for vacating order of temporary injunction, the defendant himself. Learned advocate for the opposite party has filed Hajira along with a petition praying for recalling the ex-parte order of injunction. My application, the cause shown, which was filed for vacating the ex-parte hearing of the miscase, similar cause was shown for vacating for recalling of the said order of injunction. My application, that this application for recalling the temporary injunction, which was disposed of ex-parte prior to my appearance, was rejected only on the ground. Kindly have a look at, my lord, the peculiar ground has been set out by the learned trial judge. Kindly have a look at the impugned order. Perusal of the record reveals that on 12 June 2024, temporary injunction petition was disposed of ex-parte mode, and on 24th September 2024, the opposite party appeared by filing Bhokaradama and filed a petition for recall petition. The grounds of recall as mentioned in the petition dated 29th April 2025 does not seem to be justified at this stage because the petition was disposed of ex-parte mode cannot be recalled as per convenience.
Where is the order of injunction? Show me.
My lord, I am coming, my lord. Order of injunction was passed, my lord, on 15th September 2023.
Where is that?
Kindly have a look at this. Just like it.
Yes.
And my lord,
now we want to demolish Mr. Haldar.
Well, kindly have a look at this June order dated June 12, 2024.
No, 15th of September 2023. This order you want to recall.
Subsequently, it was, my lord, disposed of. This is ad interim injunction. Subsequently, temporary injunction was disposed of. Kindly have a look at June 12, 2024.
June
12, 2024.
Yes,
Temporary injunction was disposed of ex-parte.
yes.
My lord, they took out an application for, my lord, order 39 rule 4 for vacating the order of temporary injunction which was passed in their favor. Anyhow, my lord, they took out an application under order 39. My Minoquas pair let their application under order 39 rule 4 and our application, let this kindly give me an opportunity to contest the said injunction application.
No, do you want to demolish the structure?
My lord, at this juncture, my lord, anyhow, my lord, that injunction was disposed
Nothing
of
remains.
ex-parte.
Mr. Haldar, you cannot demolish the structure. I will record that you have argued. I will record your submission, but I will confirm this order.
But kindly, my lord,
Mr. Haldar, your intention is not bona fide.
since my lord, order 39 rule
Yes,
4.
yes, I will hear you. I will recall and again impose that injunction.
My lord, that is pending.
Mr. Haldar, you will demolish that structure. How that is affects your right? You want to frustrate the decree proceedings.
Subsequently, they took out an application for injunction again. Order 39 rule 4 has been filed.
Yes. Let what what will be done, it will be done.
Well, any of
This cannot be recalled.
I'm not paying, but currently natural justice has been violated.
Yes, yes, I'm hearing you. I will record. I will record all your submissions. Make submissions on merits of the injunction.
No, my lord, that is.
I will record that.
That is to be decided by the trial judge.
Mr. Haldar, there has been a violation of the principles of natural justice. I am hearing you. I will hear you here. Please make your submissions against injunction. I will hear this on merits in the absence of the other side. Yes, please make your submissions.
I am only paying, my lord.
I'm asking you, please argue on merits. There has been a tremendous violation of the principles of natural justice. Your rights have been affected. Show me what rights have been affected. Make your submissions. Make your submissions. Please make your submissions. Why do you want to recall? I will set aside this. Please make your submission. Even in the absence of other side.
I am just only kindly directed Learned Court below to hear out all these applications.
Your recalling application has been rejected, Mr. Haldar.
All these applications to be.
No. Your recalling application will not be restored. That will remain.
But their application under order 39 rule 4 is still pending. On the same date, it was filed. I have shown to your lordship, my lord, page 26. On the same date, they took out an application under order 39 rule 4. I took out an application.
Mr. Haldar, what I can do is I can direct this miscellaneous case to be disposed of. Now you have entered appearance. I can direct the miscellaneous case to be disposed of. That will be an end of the matter.
Initially, first that injunction application to be disposed of. Thereafter, the mistake.
Which injunction? Injunction has been disposed of. Injunction has been disposed of.
Injunction, they took out an application order 39 rule 4. That is pending. That is pending.
Let that be decided.
I filed an application only relatively hard out in presence of both the
What
parties.
is your application?
My application.
Recalling. Recalling has been rejected.
My lord.
That will not be interfered with. That is no ground to it.
And that has been done.
If you want, I will record the entire facts, Mr. Haldar. আসুন তো দেখি লিখে দিই পুরোটা। This application
ঠিক আছে।
Yes, now take back. Yes, call the next matter.
Lordship, I am for the opposite party.
TPM.
Item number
37.
37. What is this matter, Mr. Raichaudhuri?
The matter relating to the locker issue I have
Who-
raised, my lord.
Who is appearing for the other side? You are appearing.
Bank.
And who is for the other side?
My lord, I have served.
Who is appearing?
Masood, Mr. Masood is appearing. This is my affidavit of service.
Who is appearing?
Mr. Masood
Where is
in
he?
the lower court, my lord. He received. I served them by hand. I served them by registered post, everything. This is my affidavit of service.
আচ্ছা ওটা একটা কাজ করুন অলরাইট আই এম কিপিং ইট টুমরো ইয়েস কালকে এটা রাখুন was your prayer
My lord, what happens, my lord?
There is
The court passed an order appointing a receiver on 8th of August. Then the court said receiver will go along with the branch manager to inventory of the locker.
yes
Subsequently, the bank said we need two witnesses to be present. Subsequently, the locker breaking agency, 2% to be there. Then a goldsmith, then 5%. So 2 plus 5, 7% will be entered into the locker. But neither the locker nominee nor myself is present. Then I prayed, if 7% can enter into the locker, why not myself?
yes why the party should not be allowed to have
There are two issues here. Number one is the deceased, the nominee of the locker is his brother, defendant number 3. Now, he is entitled to enter the locker as per the last impugned order. There it is written that the nominee can enter. Now, the banking guy.
No, in the first order does not there.
In the second order, it does.
In the second order, which I challenged.
but the first order both parties
No,
no parties
but
Now, the mandate of the bank is, as per the RBI guidelines, we need two independent witnesses. The bank manager, obviously, the person who's going to break the locker, because the keys, both of them has lost, but or police was there, etc., etc. So the person who's going to execute the work and the receiver, court-appointed receiver, who would take out the belongings. That was the order impugned also, and that was the order in which the
so the articles inside the locker will be taken over by the receiver
by the receiver.
yes
In presence of bank manager.
yes all those persons will remain
Yes.
so the nominee will also remain so what is the difficulty in the petitioner being present
My lord,
what is
as
your
per-
difficulty if so many persons are there
If the court orders, so I will do that. But my lord, the rule as per the guidelines of the bank, that prohibits, except the nominee.
the rule will not follow because of receiver's appointment is there. And High Court has
receiver
different
will
orders.
get he is also a third party officer of the so the party at whose instance this is being passed
So that is for my clarification. If your lordship passes that order, we will allow under the court's
yes,
order.
but Mr. Raichaudhuri, I am keeping it for tomorrow please can you not inform do you have the phone number of the other
Yes,
side?
I
so I'm
he is sitting in the same bar.
It's told that he has disengaged the lawyer,
who has disengaged
the defendant number 3. I mean, the private respondent.
The opposite
Here,
party.
are you willing to engage Mr. Masood tomorrow? So that the entire thing can be clarified and an order may be obtained.
I'm keeping it tomorrow see if or I will pass orders আচ্ছা এটা করে দিন কালকে orders এ রেখে দিন yes Call the 3 p.m. matters.
Similar matter. Next matter, 38.
Next matters.
This
Please,
is
this
is the affidavit of service to be kept on.
please keep it on record. Yes, call the 3 p.m. matters.
Matter number, we mentioned this matter yesterday.
Yesterday,
Because there was some, one thing is urgency is there, and also because the wrong recording has, we have already intimated to that Mr. Basu was leading me. A letter was shown to your lordship, exchange between the receiver regarding the receiver, but in the order.
can you not wait till tomorrow?
Yes, sir. Only a
There's no urgency there. Receiver,
Because,
they are from 2021.
But some matters, urgent matters
They
that
will
has
come
been.
back tomorrow. Lord.
But it can be preference first half in the, tomorrow I have spoken to Mr. Basu, he said first half he will be able to do this matter.
First up,
If lordship wishes to fix it at any time.
I do not know how, when I will be able to reach because
But there is no urgency that much I can say because Lord, the receiver of 2021.
vacation, the rush
Now
of
the
urgency
urgency-
is there.
But hotel is
So
out
let
of
me
hand.
take up because these are upgraded matters. Let me take up some of that. I will consider that because I am keep taking it up alternate days. Some one day I am trying to proceed as far as I can in the supplementary list. Other day I am giving some priority so that both
Can
of
be
you
balanced,
will, yes,
balanced.
that is why tomorrow I will consider that
We
group.
kindly consider some preference, that is the only request I make.
I will proceed serially because picking and choosing from the supplementary list will be difficult. Unless there is some pressing urgency that it is to be taken up today or
There's
tomorrow.
No pressing urgency. But they are suffering
My
Lord, from.
particular urgency is that,
Sir, can you not wait for 1 or 2 days?
yes, one day I can, and that's.
There may be some matter which cannot wait for a day. So I have to take it up. Otherwise, I will have to proceed serially. That's the difficulty. Please consider because the others are also, some other matters are also there. So I will consider that group. Tomorrow I will give precedence to that group.
For modification of this order, that's the, otherwise.
Tomorrow I will take it. Yes, call the next matter.
Item number 1240.
Yes, who is appearing? Pass over next.
Item number 712.
Pass over.
Item number 842.
Pass over.
Item number 883.
May I please, Your Lordship?
Yes.
In this matter, my lord, I am appearing for the petitioner. My lord, on the last occasion, my lord, Your Lordship was pleased to direct me to serve upon the opposite party, and accordingly, I have sent. But my lord, perhaps opposite party purposefully avoiding to receive the service because of the fact, my lord, she is contesting from the same address in the execution case. And accordingly, my lord, I have served upon the learned advocate who is appearing in the learned court below. And he has received. Give to Joseph. Come on, আমি শুরু করে দিয়েছি, আমি অলরেডি শুরু করে দিয়েছি, বলো। My lord, I may be excused, my lord, my senior.
Yes, yes.
You are appearing.
Yes, but written order has been filed. But kindly see the order, ordering portion.
Ordering portion of impugned order.
That 9th, yes, impugned order.
Yes.
9 December 2024. That written objection, record is put out the written objection.
What is this? What is the proceeding for?
But for the suit for partition.
Suit for partition. What happened? Degree.
Commissioner reports, periodic pass. Commissioner reports has been submitted. But
Final degree passed.
the final degree has not yet been.
Then why execution?
I am final degree pass. Execution proceeding is finished. Thereafter, we file an application, written objection to the commissioner report. Only commissioner report. That commissioner, your lordship, kindly see the order. Commissioner report, admittedly 2016, I did not, my lord, file any written objection. At that point, I did not raise objection also.
No, record is put up on the basis of written objection filed by the.
On perusal of the case, I find.
You are the plaintiff.
On, yes, on dated 30th July 2024, the said plaintiffs that the locus standi is rejected in limine
And so at this stage, filing of such written objection cannot be considered at the said person named such accordingly the said written objection.
Where is
cannot
the order dated 30th of July?
Yes, 30th July I have annexed. My lord. 30th July, kindly see page, my lord, 20. Yes. Page, my lord, 25. But can you see, today is fixed for appearance, plaintiff and defendant number 6 filed Hajira to lawyer.
Mr. Bhattacharya, are you the plaintiff?
I know. Yes, plaintiff and defendant number both.
All right.
Plaintiff,
Yes.
plaintiff, serial number 1, defendant number 2 and 3. 2 and 3. All 2 and 3 হবে না এটা।
Out of 4 we have 3.
We have 3. এটা তো
Out of 4.
এটা 1 আছে। এটা 3 ঠিক আছে। 1 and 3. তো এটা typical mistake আছে। Then, my lord, the learned advocate on behalf of the defendant number 1, Alok Mitro, on Ato has filed a petition stating that in the above mentioned an order of ex-parte has been passed and he has filed a petition for vacating ex-parte order, along with the petition for show cause, and the same may be considered and allowed. He, by filing the petition for ex-parte vacate, ex-parte vacate has stated that an order of ex-parte has been passed as no steps has been taken on the part he could not make any contract with his learned advocate, and when the learned advocate commissioner went to the suit property, he gained knowledge of the suit and thereby filed the petition may be permitted to contest the suit. Hard considered. The petition says, at the first instance, the court must state that whether the defendant 1 at this stage any locus standi to file such petition or not, it could be found on perusal of the titles such as that it was a suit for partition and that the judgment and order was passed on 6th May 2025. And see, Ojai Smith was the plaintiff of that suit. In the said suit, preliminary degree was passed and it was declared that each of the parties to the suit in the 1/4 share in the Schedule A, property excess such and such, directed to make amicable partition, but they have failed to do so, and thereafter defendant C, the degree holder has paid for giving effect to the preliminary degree by appointing survey pass advocate commissioner by separate allotment and said pair was allowed. But here was the commissioner has given largest share in favor of the defendant 3.
Mr. Bhattacharya, only one thing. In the impugned order, it has been said that the court has passed an order number 16 dated 30th of July that the said plaintiff has
the local standard office is rejected.
Where is that?
I did not find. But I filed the written objection on 9 December 2024. At that time, there was no written objection. And a largest share has been allotted, the commissioner has been allotted in favor of the defendant number 3. That is why they have filed a written objection. Maybe there is some delay. But
where it has been held that you have no locus, Ojay Kumar Mitra has no locus standi, where it has been said.
No, my lord. But as per order such and such, the said matter was turned down by the learned court and the commissioner.
Which page you are placing? Which page? Which page?
Page 26. Page 26.
Yes, page 26. Which portion?
That was the middle portion.
Yes.
The commissioner report was submitted on 23rd March 2022.
Yes.
And then also no objection raised filed by the defendant number 1 and the commission on the defendant number 1. And the commissioner report was accepted. Be it mentioned that the commissioner work was carried on in presence of the defendant number 1 on 25th March 2016 as could be found from his report, as the defendant 1 has also not made any objection during that time.
Who was the defendant number 1?
But I am the defendant number, plaintiff, defendant number 1.
Who are you?
1, 2, we have 3.
Who are you?
I am the defendant number 1.
You are the defendant number 1.
Defendant 1 or
plaintiff.
Please don't say. You have said the plaintiff 1, serial number 2 and 3, defendant number.
The degree holder. This is the degree.
Oh, plaintiff degree holder, please.
No, you are the defendant number 1 or plaintiff.
Ojay Mitro, Alok Mitro, and Ruby Rai. They have filed a revision application.
4 we have 3.
Yes, I know. What kind of page 14?
Yes.
Page 14.
Yes.
Ojay Mitro, plaintiff. Alok Mitro, Ruby Rai 1 and 2. And 3, Ajanta Ghosh. Ajanta is the opposite party.
Yes.
The commissioner has allotted larger portion in favor of defendant number 3. That is the main dispute I will file. After it, I file the written objection that against the commissioner report. Though commissioner report has not been annexed with the revision application, your lordship kindly see.
But Mr. Bhattacharya, where is the question of filing a written objection to the commissioner's report at this stage? Final degree has been passed.
Final degree passed.
So,
but execution proceeding,
execution proceedings, how can it be reopened, Mr. Bhattacharya?
Only defendant one,
the decree has been, final decree has been passed. You have not challenged the final degree. Then
47 pending. 47 is pending. 47.
What 47, Mr.
I don't know the appeal filed. Oh, appeal now he has filed the appeal. After
written objection, maybe
at
this stage.
Maybe. But in executive proceeding, my lord, I have filed a written.
You have not challenged the final decree. Now, you cannot file.
My lord, say they have challenged the now final decree along with the section 5 application.
So do that everything there. If you have challenged, it is set aside.
The written objection.
Execution cannot be done.
Kindly see. Kindly see. Again, I am reading, my lord. At this juncture, he is filing the petition only to mislead the court and to hinder the process of giving effect to the execution delivery peaceful.
You cannot now file the execution. Also.
What I am submitting. What I am submitting. The commissioner. 47. Kindly see the commissioner report. Kindly see. Once a bit. Kindly see.
Mr. Bhattacharya, I cannot reopen the final degree here in the execution. If you have challenged, proceed with that.
I can bring one judgment in one matter. I moved here. But before Girish Gupta, Honorable Justice Girish Bhai, in the education proceeding, that appeal was, that was the paperwork appeal was admitted. Thereafter, in High Court, in education proceeding, this is one larger portion was given in favor of one of the plaintiff. The court has entertained. But I can bring a judgment.
That is no.
I can bring. I shall bring. But I don't.
Appeal is pending against the final degree.
No, I did not challenge the preliminary degree, final degree.
Final degree you have challenged. Appeal is pending. He's saying.
Yes. Final degree challenge করেছি. Final degree challenge.
Yes, with section 5. He's saying he has challenged with section 5.
Final degree challenge করেছি. কোথায়? এখানে কোথায়? করেছি? কই? নামার কোথায়? হ্যাঁ? What I guess challenge. Okay, at this point I shall come back tomorrow.
This application under article.
I shall come back. But kindly don't. Heaven will not fall, but heaven will not fall. But I
will fall.
No. Stay has not been there. He is proceeding this execution. I know what is happening. But kindly.
This application.
But I shall come back.
It's not a question of you cannot in the execution case it cannot be reopened once the final degree has been passed. Decree.
Challenge the final degree.
Executing court cannot go behind the decree, Mr. Bhattacharya. What are you saying? This application under Article 227 of the Constitution of India is at the instance of the is at the instance of the plaintiff and the defendant numbers 1 and 2 and is directed against an order being number 22 dated 9/12/2024 passed by the Learned Civil Judge Senior Division Second Court
We have, whatever, we have filed the 47. Right?
That will continue.
But if some, this will not get any, the 47 will not embargo to proceed the 47.
47 will not be an
Only
embargo.
one line, my lord. Only
How
one.
many 47 applications we have filed?
Only one.
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 147 applications. 8, 9, 47 applications then come, not one.
Sure. Happy to file for that.
Yes. Dakun.
1303.
Yes. We are appearing.
Execution proceedings, my lord. One order has been passed, my lord, that the petitioner has to repair, the respondent has to repair the flat of the.
Where is your other side?
I have given them the notice, my lord. The service affidavit of service has been prepared, my lord. It's the affidavit of service. My lord, page 16, the annexure A is the final judgment of the state consumer forum, my lord. Page 910 is the, my lord, the operative portion. The opposite party number 1.
Mr. Minal Kanti Ghosh is appearing on behalf of the opposite party.
Where is he?
Not here, your lordship. It's not here. I'm being instructed he's not.
Where is he?
Probably
He's not here.
probably in a,
Where is he?
probably in land tribunal, your lordship.
My lord, in
Yes.
that case, my lord,
Can be
may I-
taken up tomorrow, your lordship.
my lord, may I pray for my lord stay of execution application, my lord?
What is happening? Stay of execution. What is the next date fixed in the execution?
9th of October, my lord. And if
9th of October.
my lord, if matter will not be taken during this vacation, my lord, then my lord, the warrant will be issued, my lord.
Take it up tomorrow in presence of Mr.
Tomorrow.
Ghosh.
All right.
Somehow, my lord, matter is
Then remind me tomorrow. Yes. Next.
Item number 842.
We have the petition.
Yes. Item number?
What?
Also that will be. Yes.
My lord, plaintiff opposite party filed an eviction suit regarding the recovery of khas position regarding a shop room, my lord. Here, the defendant petitioner filed an 7-1 application and they are directed to file a rent of 291 per month. Then after that, they filed 7-2 application, where this in the 7-2 applications, learned judge has not seen where the given the direction has given to file the rent, but defendant has filed up to 2018. Up to 2018, the defendant had filed the rent, but overlooked the rent receipt and said that in 7-2 that rent has as directed by a 7-1 application that defendant had not filed rent. That's why 7-2 applications as dismissed. And also in the suo motu 7-3 also taken over. Kindly come to the impugned order, my lord. Dated 25/2024. The second page at the bottom line.
Yes. Yes.
Yes, my lord. The defendant had filed the rent up to 2018. The 71 in 7171 filed in 2015. After that, defendant has filed up to 2018, my lord. Rent receipt over there, my lord, in the court, my lord. And in the 72 application 73, the defendant's defense has been struck down. That's why I am saying that although the defendant had filed, deposited in the court that up to 2018, that means he has obeyed the court orders, but not continued. That is the fact. But
not continued.
Not continued means up to 2018, defendant has filed. But
after 2018, what did you do?
He has not deposited. That is the fact, my lord. Kindly, if my lord, this is a defense is struck. It
has to be.
Is kindly
has to be struck off.
Well, up to 2000, we have filed up to 2018.
Yes, up to 2018. After 2018, if you have not deposited, defense will be struck off.
But here it said that in their own risk.
Yes, yes.
That is a fact that the defendant has said in the risk is upon the defendant. That's why.
This application under Article 227 of the Constitution of India is at the instance of the defendant and is directed against an order being number 131 dated May 20, 2024, passed by the Learned Civil Judge Junior Division, First Additional Court, Purbo Bardhaman, in title suit number 59 of 2014. So by the order impugned, the application under section 7 within bracket 3 of the West Bengal Premises Tenancy Act was allowed, thereby striking out the defense of the petitioner for delivery of possession. First of the learned advocate appearing for the petitioner submits that the petitioner deposited rent in compliance with the provisions of section 7 within bracket 1 till the month of
December 2018,
till the month of December 2018. Full stop. However, the learned advocate appearing for the petitioner, in his usual fairness, submits that rent after December 2018 was not deposited. First off, he submits that the petitioner be permitted to deposit the area rent along with interest. First up, it is well settled that if the tenant fails to deposit or pay, it is well settled, correct. Section 7 within bracket 3 of the West Bengal Premises Tenancy Act states that if the tenant fails to deposit or pay any amount referred to in subsection 1 or subsection 2 within the time specified therein or within such extended time as may be granted, the court shall order the defense against delivery of possession to be struck out and shall proceed with the hearing of the suit. First up, admittedly, the petitioner did not deposit the rent after December 2018. First up, thus, there was non-compliance on the part of the petitioner. Thus, there was non-compliance on the part of the petitioner of the provisions of section 7 within bracket 1 of the 1997 Act. First up, the learned trial judge, after considering the materials on record, arrived at a factual finding that the defendant has failed to comply with the order of the court and the provisions of law as incorporated under section 7 within bracket 1 and section 7 within bracket 2 of the West Bengal Premises Tenancy Act 1997. First up, the learned advocate for the petitioner in course of his argument could not controvert such factual finding arrived at by the learned trial judge. First up, the impugned order does not suffer from any infirmity warranting interference under Article 227 of the Constitution of India. Accordingly, CO number such and such accordingly stands dismissed. There shall be, however, no order as to causes. Yes, next.
Item number 361, My lord, I am for the petition.
Yes.
My lord, my application under Order 6 Rule 17 for amendment of the WS has been rejected by the learned judge, my lord.
At what stage?
My lord, the cross-examination of PW1 is going on. At stage, because my lord, at this stage, my client filed an application because during the cross-examination, plaintiff number 3 executed a special power of attorney in favor of the defendant. So that fact should be incorporated before the learned court, brought into the notice of the learned court for proper adjudication of the case, my lord.
Where is your prayer for amendment?
My lord, that is Annexure B at page 23.
Non-suit plots.
Yes, lord.
This application under Article 227 of the Constitution.
Smooth access.
Who are you?
I'm for the mother, my lord.
Yes. Now what happened? Now this is being continuing.
No, my lord. No visitation, my lord. No visitation after this order. only once tried, my lord, but
Direction upon the
but that is failed.
On every Saturday and Sunday,
Yes, I could not, my lord. My client could not visit.
why?
But this was
I do not know whether the district project officer, child project.
this report, my lord, was directed to
Report or not. Under
The
this
re-
permission,
next page, my lord, department is directed to communicate the order of the site.
daughter is refused to meet with her, stay with her husband, with her mother.
During the subsistence of the marriage, my lord,
But child-
the opposite party married another lady,
that is
and she died,
that is-
and one criminal case initiated under
that is the entire that is
304B.
that is a concocted story. Daughter is not willing to meet her, stay with her mother. He herself refused to stay with her mother. Earlier, two occasions, daughter produced before the Senate court below, and she says that I will not meet with her mother.
Right.
Have you seen the statement of the child?
On its basis, my lord, the order was passed, my lord, and that is under challenge. My lord, kindly see the
No. After that, before the child protection officer. 4 PM আছে তো বোধহয় 4 PM টা দেখে নিই। এটা কত 25 who is appearing in 225 pass over yes
4 PM matter. Item number 420.
12 you are not here Mr. Banerjee what can be done tomorrow others have to be given chance after rotation he will get chance after this matter ask Mr. Chakraborty how long he will take this is also an alimony matter let me see yes
Lord, first to clarify whether there was application made by or not. Mr. Mukherjee was vociferously saying it is made. Just to clarify that, not order a copy to the. But yesterday he handed over a copy of the orders of the trial court, but I have scanned it from his junior. And only given to it. Just take this so that I can refer from the page numbers. Within the sahib ke. It is only. Yes, the page numbers have been put in. Sure, dorkar nahi hai. Lord, kindly, Mr. Mukherjee was submitting that we have filed another application, which is stated, Lord. So he was taking a point that we cannot proceed parallelly. Lord, kindly straightway come to number 19 of the order of bunch.
yes
Page number, which is find the order number.
yes
That's the first order which is under challenge. Lord, by that order, the trial court directed to them 1 lakh per month. So can you take thereafter order number 50?
50
next page, page 21. Because this petitioner allows an application 150. So you find the 151 application, which has also been rejected, which is also under challenge before your lordships.
what is 151 this is for from the date of the application
From the date of the application and the litigation cost.
yes
Right? Then kind of not turn to next page, order page 22.
yes
December 23. So objection copy served. Madam, can you get that? So objection to the 151. Then kindly take the next date. 1st January page 23. Learning advocate. Some document page 23. Then when you come to page 26.
yes
Which case number frames in the judge. To do is fixed for hearing, parties files Hadira through respect that on behalf of the petitioner wife, DMF annual report 24 in respect to the yearly income of the respondent husband is filed. Let it be kept with the record on perusal. This case is already disposed of. I will run 48 days such and such.
Chakraborty, why did you file this annual report
Lord,
for
Lord, one
in connection with what
in connection with that 151 application which is pending.
in connection with 151 is with effect from the date of file
Lord, what we have done, we got to show that the husband is concealing his income. The court says,
Mr. Chakraborty, there are two things. 151 is only not the quantum, it's only from which date. Nothing.
It was wrongly presented to the court. It ought not to have been done.
The annual report.
Because the wife got to know that he has changed his job. He posted in TNF, did not disclose, he produced. Then kindly see the next line. Having regard to the aforesaid aspect, fixed on 20th for hearing objection time. He didn't file any objection. Then kindly not take page number 15. In between, nothing happens. Application filed. Only two dates are there. Page 27, PO is on transfer. Page 28, PO is transfer. Page 29, 29 November, 51 is dismissed. Where from he got it? And he came and started shouting that there is an application. Yes. So, may I now proceed with the main matter? Now, kindly take up the compilation that I have given to your lordships. Lord, I'll be very precise. Within 10-15 minutes, I'll finish my submissions, Lord. My lord knows all the judgments. I will not trouble your lordship with that. Just refer. I'll kindly take the compilation that I have given to your lordships. And lord, the impugned order, the first impugned order, that is 31st August impugned order.
Show me your 151 application first.
Yes, my 151. Lord, should I show your lordship the main application where I have claimed? Take the 151 application
with effect from the date of
page 110. Page 110 of the revisional application.
of the revisional
application.
Yes. Yes.
Lord, my lord, keep over the first three paragraphs. There is nothing. It is submitted. No para 4, no litigation cost was awarded in favor of the petitioner by the learned court. Though petitioner has paid for litigation cost before the court amounting to 3.5 lakhs, it is further submitted as per opinion of the apex court. Nowadays, while an order passed by the learned court is relating to maintenance in favor of the petitioner, that ought to be passed. This is the date of filing of the application of alimony pending. It is submitted further that in the light of the aforementioned facts and circumstances of the case, unless the learned court be pleased to direct the respondents to pay monthly maintenance in favor of the petitioner, her minor daughter from the date of filing of the alimony pending as well as the litigation cost in favor of the petitioner. This has been rejected by the second impugned order by saying that nothing is to be looked into, you go and challenge the main order. For the present, kindly ignore the documents given with that application. Lord, nothing was spread. Only it was brought to the notice that you do it from the date of the application and litigation cost.
No, where it has been said that you go and challenge the main order, where it has been
No, the court did not entertain last order, the 29 November order.
Yes. No, you said the court said you go and challenge the main order where it has been said.
Court did not entertain. Court said I cannot go into that. No, it was
not said that you go and challenge the parent order.
Well, that's the meaning of that. I am not interfering it. Well, kindly have a look at it. Kindly have a look at it.
Yes.
In case in hand, second page. In the case in hand, there is no scope available to the petitioner challenge 31st August. Last line of the first paragraph of page 2.
Last line of yes, in the instant case has already been disposed of since the stands rejected.
No, before that, no, the last sentence of the first paragraph. In the case in hand, there is no scope of alternative remedy available to the petitioner by challenging implementation so and so. Then he says that in the instant case has already been disposed of since 151 stands disposed of. Yes. Lord, kindly come back to the first order once. Just take the pen to come to the first order once, 31st August. Lord, I will. Lord, my submission has two components. One, it has to be from the date of the application. But the law is very well settled. Rajneesh versus Neha has taken care of all eventualities. Everything has been discussed there. My lord has multiple times seen that at a copy though. But just finish on the question of date of application. Then I'll take your lordships to the issue. Kindly have a look at this. And your lordships court own judgment and our court's judgment. Kindly have a look at Rajneesh versus Neha once.
Yes.
Which kindly straightway come to para 94.
Yes.
This is the heading. IV Roman 4. Not SCC page 375. I believe SCC page 375, para 94.
Yes.
Date from which the maintenance is to be awarded. There is no provision each in from which the application order section does not put from the date from which the is to be awarded. Section 222 CRPC is the statutory provision which provides that the magistrate maintenance either from the date of the order or from the date of the application. In absence of the uniform regime, there is a vast variance in the practice adopted by the family courts in the country with respect to the date on which the maintenance must be awarded. We need to take a the conclusion. Conclusion that like have been discussed from the date of issuance of summons, from the date of application, and from the date of order. And kindly come, minority give those eventualities. A, kindly have a look at A, para 96 date of application. Then B, C, summons. The discussion.
Yes.
The judgment here reveals that different high courts in the date from which the maintenance must be awarded, even though judicial discretion is conferred upon the court to grant maintenance either from the date of the application or from the date of the order of section 125(2). It will be applicable to grant maintenance from the date of the application in all the cases. Including 125. In practical working of the provisions relating to maintenance, we find that there is a significant delay in disposal of the applications for interim maintenance for years on end. It would be therefore be interest of justice and fair play. The maintenance is awarded from the date of application. But kindly skip over para 110. The rationale of granting maintenance from the date of application finds its roots in the object of enacting maintenance legislation so as to enable the wife to overcome the financial crunch which occurs on the separation from the husband. Financial constraints of a spouse hamper their capacity to be effectively represented before the court. In order to prevent a dependent from being reduced to destitution, it is necessary that the maintenance is awarded from the date of the application where maintenance is filed before the court. In para 113, it is therefore become necessary to issue directions to bring about uniformity and consistency in orders passed by all courts by directing that maintenance be awarded from the date on which the application was made before the court concerned. The right to pay maintenance must date back to the date of filing of the application, since the period during which maintenance proceedings remain pending is not within the control of the applicant. So considering everything, this is the law laid down. Now, one more judgment I would like of the application. My date of filing of the application according to the court order, it is 10th of August, but we filed it on 6th of August. 10th of, let it be 10th of August. We are only one August of 2020. Wait about the age judgment of 2020. Yes, 2012 4 CH into the Lord, just one more judgment I would like to. There are Supreme Court's High Court 2012 4 CH.
And when the order was passed?
31st August 2023. Lord, have a look at this one. Here Mr. Mukherjee appeared and Lord prayed for what I am saying. He must have forgotten by this time. So I am reminding him. 2012 4 CHN Lord 380. Baba Devo. Baba da bhule geche. Kindly have a look at the second page once. Lord, third paragraph, Mr. Bidut Banerjee Malaras Kali got that? Second page of the report. This is the paragraph number given. Yes, yes. Mr. Bidut Banerjee, learning senior advocate, Mr. Mukherjee was assisting Mr. Banerjee. Trial application. So, as a the Kamal Kumar 68 CW that was held that the maintenance should be awarded for the service of the summons. Then can we come to the next page? Having heard the respective submissions of the parties, there emerges 2 points. Statutory bound the order of maintenance. The application subsequent order. But this point has been discussed by Justice Tandon. Kindly come to the next page after the court has quoted Lord 97 Supreme Court. Kindly come to the observation of Justice Tandon. Manas got the division bench of this court. The division bench of this court, Supra held that maintenance should be allowed from the date of service of principals petition by date of service of the summons of the divorce petition by placing reliance upon the another division bench judgment of Srimati Shobana so. However, the division departure relying on laying down the ratio that there is no evidence that the maintenance should be granted from the date of the original application for judicial separation, but it depends upon discretion to pass an order either from the date of the said application claiming maintenance or subsequent thereto. From the enunciated in the above reports, the grant of maintenance either from the date of initiation of the original action or from the date of the application from period subsequent thereto is within the discretion of the court. Such discretion would be exercised with sound reasons and logic on the facts and circumstances of each case, unless such discretion is found in the superior forum should slow to and circumspect so and so. In the instant case, the petition under Section 27 Special Marriage Act was filed in 2006. The petitioner rendered appearance on 8 March 2006. The application under Section 36 of the said act was filed immediately thereafter on 29 March 2006. It cannot be said that the petitioner having waited for considerable period after taken out the application for alimony, the while passing the alimony from the date of the order did not record the satisfaction in that regard. As indicated above, there is no or latches on the part of the petitioner in filing the application for 36, and it would be unjust and unreasonable that alimony should be ordered from the date of the order by which the said application under 36 of the said act is disposed of, but it should have been allowed from the date of the application. Here in the instant case, I have a duty to clarify that suit was filed on 22nd April 2019. Lord, I was in service till September 2020. I gave September 2020. To my daughter's education, I gave my resignation in August 2020, and in August 2020, I filed the alimony application. So there is not even a delay of 1 day in the court. I was working, I could not have prayed. So your lordships, my lords have laid down the law that multiple factors have to be considered. The standard of living. Lord, the wife is not a person, Lord, from the street. My lord knows that petrol pump, Lansdowne service station, that was owned by their family. So she comes from a reasonably, Lord, well-being family. She is an educated lady. Her educational qualification and the aspect of Lord work experience has been admitted.
So this is on the from which date it is to be paid.
Judgments are there. My lord, the copy. 97 Supreme Court, page 7, 97 7 is
the date of the order.
Application. Date of the order was granted on the facts of the case by the Supreme Court. It has to be on the date of the application.
97 Supreme Court says date of the order.
On the facts of that case, but the law laid down para 9. Last sentence.
And where is the other judgment of Justice Tandon which says it is to be not from the application, not from the order?
I'm giving
but
circumstances. See the circumstances in 97 Supreme 97 SCC. Have a look at it. The circumstances.
Have you got the other judgment of Justice Tandon? Which
Lord,
says,
I am
not
carrying
from the date of the application, not from the date of the order, and from an intermediate stage. Have you got that judgment?
All depends on the circumstances of
Have you got that judgment?
I have got 3 more judgments for your consideration. One judgment which is completely against me. But those facts are different. My lord, you have to see whether these attending circumstances are there or not. Para 9. Just have a look at para 9. The circumstances said by Supreme Court. The question that arises as to from which date the wife would be entitled to claim the enhanced amount of maintenance from utility. If the wife has no source of income, admitted no source of income, it is the obligation of the husband to maintain her and also the children of the marriage on the basis of the provisions contained in the Hindu Adoption and Maintenance Act. Her right to claim maintenance fructifies on the date of filing of the petition. For divorce under the Act, having thus fixed the date as the filing of the petition, for divorce is not always that the court has to grant maintenance from the date. The court has the discretion in the matter as to from which date the maintenance.
Yes.
So these attending circumstances are not available here. Now, one thing where the court says, your lordship's court says that the husband has to take this point. That look, you have to give it from the Justice Provis Samanta's judgment. But the husband has to say that due to this reason, you don't allow from the date of application. Allow it from the date of order, if you allow, do that. Now, this is, I couldn't get it from the SCC online. This is reported in Monopatra.
But
this judgment, Justice Samanta's judgment. বাবু এটা একটা নাও, এটা তোমার মনোপত্র তোমার নিশ্চয়ই আছে, তাও তোমার নেই এটা হতে পারে। হ্যাঁ, para 3 didn't get it in the SCC online. I could have got the High Court site order, but para 3 can have a look at it. On the question as to from which date the wife would be entitled to claim that the is very small. That the court has the absolute discretion in this matter. Exercise of the said discretion will depend on the multiple circumstances. In the particular case, husband petitioner has not brought to the notice of the learned court or this court as to why the wife has been entitled to a maintenance, at least from the date of making of the application. So they have not brought anything before the trial court. I don't know what would be his submission before the lordship court, that it has to be from the date of the order. Therefore, the main criteria for determining the date from which the said spouse would be entitled to maintenance would be the date from which the other spouse was under obligation to the application for maintenance whatsoever to establish that even after the date of making the application, husband will discharge the obligation.
Yes, I've seen this. Yes.
And
these are all with regard to the from which date.
Which date? And my lord must have seen this 2000. I'm not citing this. It was very categorically. If today, not the trial court held that he is under obligation to pay. Kindly consider this. Trial court held that I have a right to get maintenance. My daughter have a right to get maintenance. No, but right has emanated that time he has filed. No, it is not a maintenance. It is for sustenance. Alimony. It is different from maintenance. My lords have laid down the law. So to sustain, you cannot just say, I'll continue with the proceeding. After 5 years, when you are at the verge of death, I'll give you the order. And one more information to your lordships on this. The alimony application was filed on 10th of August. That order bunch, take that order bunch on your lordships left hand side. এই নিচে আছে, নিচে মাইকের পাশে যেটা আছে ওইটা তোমার থেকে নিয়ে দিয়েছি, আমি কিছু দিইনি। হ্যাঁ, ওই যে যেটা ওইটা একবার নাও।
Yes.
And kindly come to page 4.
Yes. Yes.
10th August, I filed first order. This case is registered. I filed the alimony application. Now kindly come to page 7. Page 7. Page 7, first order. Malwas got that? 2021. 7. Order number 1. ভারত নাড়ছে না, বুঝতেই পারছি না। পেয়েছো? I mean, page 7. Can you see first order? Respondents files W. August 21. 10th August 20. At TX filed, he filed his objection after 1 year.
When he filed,
7, the page numbers are at the top right hand side. Page numbers given, order number 21, 20, first order, respondents filed W. So who delayed it? Only 1 day, my lord, I tell you, only 1 day that we should give the order. Can you come to next page? Take page 8. See how diligent the wife was. Oh, sorry, I'm sorry. Page 8, yes. Page 8. Order number 25. Just have a look at it. And is that page 8? Order number 22. Speaks OP files Sajida and is present before the court through learned advocate. Both steps taken the 5 file. Can you see the next order later? At one point, the show is filed. I was waiting inside the courtroom. I could not find the proceeding. The moment the show was within 1 hour, I filed the show cause. So I have not delayed it even for a day.
yes,
For the present, your lordship is hearing us. I have one lord most humble suggestion, or lord prayer before my lord, if my lord allows me to make lord. Lord, if my lord is weak, if my lord, I have 2 components that enhanced and from the date of application. If my lord is weak, if my lord grants from the date of application 36 lakhs on the same rate, I will be entitled. If my lord is not with me, then also I will be entitled 1 lakh which I am getting. Let him pay some ad hoc amount now. If I fail to satisfy your lordship, it will be adjusted with the present maintenance. At least so that the daughter's study doesn't get affected. Just have a look at this. Then my lord decides. I leave it to your lordship.
Yes, Mr. Mukherjee.
Although the husband is not here, but the husband is saying that they never permit the daughter to talk, and not they never permit the daughter to talk with the husband. And my second thing is that whatever my
It's so, Mr. Chakraborty.
She is in class 12.
I'm telling you, lordship.
All right.
Second thing is that my lord, recently we have paid
Mr.
some of the fees.
Chakraborty, you have to make your daughter understand.
See, with the father. Father comes, take her with the restaurant.
The father's mail
Please,
today morning.
please, Mr. Chakraborty, please take instructions.
Today's mail, kindly.
Please take instructions.
Recently he has
Last
paid.
Last Sunday he met. Last Sunday. Last Sunday he met.
Kindly see.
বাবা last Sunday দেখা করেছে ভুল হচ্ছে মক্কেল ভুল বলছে
And I will give a printout copy to Mr. Chakraborty.
last Sunday he met
মোবাইলে কি এমন আছে বার করিস না
last Sunday they went to Chile South City
No, Quest Mall.
Chile's Quest Mall had dinner with the daughter lunch last Sunday 14 September.
Kindly see this.
Mr. Mukherjee, please take that they are saying that
Yes.
I'm showing my
talk to the daughter
not my person.
She can talk to the daughter.
No, Mr. Chakraborty, you may fight. Both of you fight. There is no difficulty.
But
After all, see, after all, he is the father of the daughter.
For SAT examination, my
As you are the father of the daughter, he is also the father of the daughter.
100%.
So please see that the
Yes,
please see that the father.
The page I have handed over, would you just have a look at that?
Yes, I will. Yes, how much
The
I will.
page that I have handed over, just have a look at
kindly
this.
keep it Monday malad at 4.
Just have a look at this note. This is just let me place this.
আমাকে
দিচ্ছি বাবু একটা কপি দাও না
But my instruction SAT examination fees has been paid by the husband. Now husband what more study he want because he is in class. He is in class 12.
তুমি দেখো এটা আমি দেখি লিখে দিয়েছি just have a look
He is
at it.
class 12.
But the daughter,
All right, you have to do this. Mr. Mukherjee, please consider this.
Consider this.
After all, one thing.
Absolutely.
It's after all the education of the daughter.
He agreed.
After all, your daughter. So if after all your daughter, please with the education, you also want your daughter.
Husband is saying that at least I should know that what study she will do in the that they are not communicating.
Mr. Chakraborty, please ask the daughter
To tell everything about the particular to take
talk
admission.
with the father. What is the studies? Which course, where?
Ask the daughter, take Mr. Mukherjee in conference and talk to the father.
Mr.
So that he gets satisfied.
That's up to.
This is something is wrong.
Yes. So
Father daughter having lunch together in South City Quest and coming and saying.
father has to know where she will be going.
It's my duty. I'll give you all details. Lord, my lord keeps it tomorrow. Give it to you. I've given a copy. দিয়েছি।
ওইটার copy দিয়েছি?
এইটাই, এই Emily নাও।
Heard,
Sir, my lord keeps it tomorrow at 4 p.m.
Tomorrow 4 p.m.
tomorrow it will not
Monday
be.
কাইলে
Monday.
Let it
ওই
appear.
যশের
No, Monday.